Yes, please, Your Lordship. My Lord, may kindly please to turn to the overleaf of the mentioned memo, my Lord. This Honorable Court is directed as and given liberty by order dated 1/10/2019 to mention before DB1, if case of an urgency, my Lord. This is the petition of 2014, and final hearing to be done, and petitioner suffered a massive heart attack, and he's under treatment. So any date suitable to this Honorable Court may be pleased, my Lord, to this matter of hearing. This is matter pertaining to pay scale and would not take more than 10 minutes, my lord.
ठीक है वीक कमेंसिंग
Any suitable date, my lord.
26 वाले वीक में लगा दीजिए नेक्स्ट वीक
बदलाव सकते हैं
यस
New petition of the writ appeal, order SHRI, where the Honorable Court directed to remove the encroachment within a period of 45 days, whether the petitioners were never heard and never the party in the, before the writ petition or the writ appellate. And now the SDM has issued notices to remove the construction within a period of 3 days only. I have preferred this review petition. And there was a contempt petition also pending, Your Lordship, wherein I intervened. And the court has directed the authorities to remove the construction within a period of 2 days, and the matter was fixed on 27th of this month.
Then what happened?
So it has said the SDM has issued the notices, SDM and Tehsildar has issued the notices to remove the construction within a period of 3 days only. So I am here before this honorable.
Review petition.
Yes, yes.
You are not a party, no?
Yeah. Neither in the writ petition nor in the writ appeal. The writ petition was dismissed and writ appeal was allowed. And in the writ appeal, this honorable court has directed to remove the.
नहीं तो ये सब एनक्रोचर्स हैं इसलिए इस पिटीशन में पार्टी थोड़ी बनाएंगे
इनके अगेंस्ट 250 की प्रोसीडिंग्स हुई थी, so they were the necessary parties in the writ petition, because they are going to be affected with this. I'll demonstrate before this honorable court that how they were the necessary parties in that petition and the writ appeal also. This case will go before the special DB. This case will go.
और फ्राइडे को लगेगा तो
So because
फ्राइडे
so my anxiety is that Friday तक तो they will demolish.
Why don't you file a writ petition separately?
Sir,
इसके खिलाफ करेंगे हम पार्टी नहीं थे वहाँ पे
वो writ petition जो लोग पार्टी जिन लोगों के against 250 की proceedings नहीं हुई थी, they have filed and the court has granted stay in their favor. But now the review petition was filed by the person who was the party before the Tehsildar, who preferred the appeal before
the single bench order.
So honorable single bench has granted.
जो डॉक्यूमेंट्स दिखा पाएंगे लीगल डॉक्यूमेंट्स वो डिस्कस नहीं करेंगे बाकी लोगों को डिस्कस करना ही पड़ेगा दैट ऑर्डर हैज अटेन्ड फाइनलिटी
Sir, what hurdle order? Sir, my hurdle since the honorable division bench passed the order against me, so the writ petition is not at all material about bench. So वो इशू उसमें
तो फ्राइडे ही बनेगा ये तो स्पेशल बेंच अभी बीच में नहीं बनेगी
सर मेरी एंजाइटी है वो ये है कि सर 3 दिन का नोटिस है demolition notice and they will demolish my review petition.
प्रिंसिपल बेंच से परमिशन लीजिए अगर कल वाल सुनना है इसको कल परसों they will constitute a special bench यहाँ से नहीं होती बेंच वो हाँ रजिस्ट्रार के सामने जाइए वो वहाँ भेजेंगे वहाँ से कॉन्स्टिट्यूट होगा लाइए
सर अगर आप इसमें
नहीं हम लोग नहीं कर सकते हम तो फ्राइडे को दे देंगे आपको जिस दिन स्पेशल बेंच है बेंच कॉन्स्टिट्यूट करने का पावर प्रिंसिपल सीट को है
डेफिनेटली
यस
जो बेल एप्लीकेशन फाइल है एप्लीकेंट के फादर की कंडीशन सीरियस है
कब फाइल किया आपने
लॉर्डशिप 19 तारीख को
आज ही तो 19 है
लॉर्डशिप सॉरी 14
को तो नहीं लगाइए अभी तक चलो इसको सब्जेक्ट टू वेरिफिकेशन है ना वेरिफिकेशन करा लो डिफॉल्ट होंगे तो देख लेना पड़ेगा
लॉर्डशिप डिफॉल्ट्स नहीं हो
क्या कर लेते हैं
Yes, sir. Also, this mention memo is filed by because the IE has not been updated, Lordship. That is filed on 12th January, Lordship. And this IE was filed in compliance of the order dated 9th January, Lordship.
General admission challenge. Tomorrow.
This is a writ appeal. There are a direction has been issued by this honorable court for removal of the enforcements from the appellant's land. Some persons filed a writ petition, and in that writ petition, some directions have been issued which would virtually nullify the order passed by this honorable. And the compliance has still not been effected by the authorities, but now
यहाँ DB से order हो गया. Final होगा ना?
Yes, Your Lordship. Some other persons who were not parties, they filed a petition saying that they are being thought to be dispossessed.
They didn't disclose the order of this.
They have disclosed, but the directions issued by the honorable single.
Tomorrow.
Lots of temporary suspension में अपलांट फादर डेथ हो चुकी थी.
किसकी डेथ हो गई?
अपलांट फादर की डेथ.
Appellant's father. Tomorrow.
लॉर्ड शिप
वो डेथ कब हुई?
11 तारीख को हुई थी. 15 तारीख में फाइल कर दी थी. और मुझसे भी सर सैटरडे की थी, लेकिन सेटल में भी अलर्टेड नहीं होने के कारण से लग नहीं पाया था. 21-22 को कार्यक्रम
के लिए लगा? काय के लिए लगा?
डीबी नहीं थी लॉर्ड शिप.
कब? किसके डीबी का दिखा ना?
स्पेशल डीबी का, सेकंड डीबी नॉट
स्पेशल डीबी. तो आज कहाँ है डीबी? आज भी नहीं है.
नहीं लॉर्ड शिप आज तो सिटिंग दिख रही.
नहीं सिटिंग दिखना वाला वेडनेसडे थर्सडे रहती है ना स्पेशल बेंच. कब रहती है?
मतलब मंगलवार कल भी रहती है लॉर्ड शिप.
आज नहीं है.
आज नहीं.
तो अगर देख लेना डीबी अवेलेबल है तो, नहीं तो फिर परसों लेट हो जाएगा.
फिर इस कार्यक्रम में लिखने के लिए इलेक्शन.
मंडे नहीं फिर ये रूसिया साहब एंड
मंगलवार.
अरे मालूम नहीं तो फिर कहाँ कहाँ लगवा देंगे इसको. मालूम करके आओ पहले किस डीबी में लगेगा, तो उस हिसाब से ये चार्ट को देखते हुए डेट देना पड़ेगा.
इस हिसाब की.
ये दूसरे कौन है जज साहब?
जस्टिस अनिल बेरो साहब.
वो बुधवार को है डीबी. बुधवार और गुरुवार 2 दिन का प्रोग्राम आया हुआ है. तो क्या करेंगे इसको?
कार्यक्रम
वहाँ नीचे नीचे मेंशन करो, वहां से स्पेशल डीबी अगर बनती कल की हो जाए. नीचे रजिस्ट्रार क्या मेंशन करो, जबलपुर भेजते हैं, वहां से डीबी बन के आती. फिर वो
मेंशन अलाउंगे जो लड़सुप तो करेंगे, नहीं से ऐसे नहीं कर पाएंगे.
नहीं नहीं भेजो, आप भेजो. कोर्ट ने बोला कि नीचे मेंशन करना, ऐसा बताओ उनको. ठीक, चलिए नेक्स्ट. वहां से परसों कभी नहीं करेगा.
This case, my lord had granted the mention on Friday for today. Unfortunately, the number was wrong, therefore it was not taken up. I request it to be taken up today.
अब क्या करेंगे? नंबर गलत है तो कोर्ट स्लिप तो दिया आपको.
My lord. तो आज
कल की कल की अब नंबर सुधारो. देखो
नहीं, वो सुधार दिया था सर, उसके बाद फ्रेश भी दिया था, बट अनफॉर्चुनेटली इट वाज नॉट एंटरटेन्ड बिकॉज
क्या अर्जेंसी है केस में?
उसमें डिस्पोजिशन का
आ गए पीओ आ गए होंगे, 1 दिन की छुट्टी पे थे वो. कुछ
उतने 3 दिन की सब आज भी नहीं.
आज भी नहीं. चलो ठीक है, आज बोलो.
The Tehsildar under political influence has been conducting the proceedings under section 250 day-to-day basis, my lord, and the next date is 20th. Whereas the demarcation is in my favor, my lord. Due to political influence, they want to, my lord, remove me from the position. And it is a developed colony where people are living.
tomorrow.
Number 1. Please, my lord, this is a detention matter. My lord, it was heard and reserved, and thereafter it is released, my lord. As of now, my lord,
The marketing of cylinders.
yes. As of now, my lord, detinue has already been released, so there is no urgency. So maybe pray for 2 weeks time, and thereafter, my lord, no issue.
Everything survives in this petition now. Whether this some cause survives or not.
They wish to contest it, my lord, says.
So ऑर्डर को क्वॉश कराना चाहते.
They wish to contest.
ठीक है, हो गया. This petition is to be heard finally list after weeks.
Number 2 wish to contest. One cross suspension, मतलब reply file pass.
फाइल होना। तो अपनी कस्टडी कितनी होगी? ज्यादा
बट 2010 से कस्टडी में।
तो फिर ऑलमोस्ट 12 13 हाँ 2012 के बाद पहली बार लग रहा है 2012 ये देखो पहली बार 2012 के बाद लग रहा है पहली बार
मालूम बस टाइम फाइल किया है मालूम सस्पेंशन।
ठीक है 2 weeks टाइम टू फाइल अप्लाई
एक बार पास हो
अप्लाई है इसमें तो इसमें अप्लाई करना बस।
There are two applications listed today. One is for suspension of sentence, another is for dispensing of affidavit.
तो ये ना आर्ग्यू करिए सर इसमें रिप्लाई फाइल होना चाहिए।
इनपुट टाइम तो आर्ग्यू देंगे
आर्ग्यू टुडे अरे भाई देखो एडजमेंट दे रहे हैं 35 केस लगने लग गए पहले 20 लग रहे थे क्रिमिनल अपील्स नाउ 35 वी हैव टू डू अदर वर्क आल्सो सस्पेंशन ऑफ सेंटेंस थोड़ी कर रहा है बिकॉज ऑफ एडजमेंट्स वो बढ़ते जा रहा है नेक्स्ट वीक तो वो सब एक साथ नेक्स्ट वीक लग जाते हैं सर लास्ट में व्हाई शुड वी ग्रांट यू अगर नहीं बहस करना तो विड्रॉ कर लो एप्लीकेशन जब आपकी इच्छा होगी तब लगा देना फिर यू हैव टू ऑप्शंस
हम्बल सबमिशन को लगा सकते हैं जर्नल लॉजिक
रिकॉर्ड आएगा इसमें नहीं है connected door being allowed registering directives and original records for the court scan it ओरिजिनल था वापस किया पर उसको स्कैन करके रखने का डायरेक्शन था ये देखो ये आधार था अपना स्कैन रखा है इसमें पता ऑर्डर नहीं रिकॉर्ड फ्लोर करके रिकॉर्ड 197 803 रिकॉर्ड पे रहते हैं स्कैन
स्कैन तो है मेरा फिजिकल।
हाँ तो फिजिकल कहाँ से आएगा अभी वापस किया जनवरी में पीयूडी आई थी वहां से तो रिकॉर्ड हैज बीन सेंट बैक विद द डायरेक्शन टू कीप द स्कैन रिकॉर्ड हियर करिए बहस करिए
नेक्स्ट वीक तो रखते हैं नेक्स्ट वीक में रखते
नेक्स्ट वीक नहीं फिर आफ्टर 4 वीक्स जाएगा
हैं 4 वीक्स
we cannot ready to argue the matter list after 4 weeks scan record is available
नंबर 6
number 6 में रिप्लाई फाइल बट नोटिस रिक्वायर्ड है
सर लास्ट डेट पे आपने एसएचओ कॉल किए थे कि 5 डेट से नोटिस सर्व नहीं
ये वाला गाड़ी है कैप्टन पे पास होगा where is your SHO sir pass over
नंबर 7
नंबर 7 में भी पास होगा नंबर 7 में भी पास होगा SHO
You have taken the week's time to file the application for continuation of DA.
second set is not available this is a division based 2 sets are required to be filed
But I'll cure the defect.
and clear करो एक हफ्ता 1 week time to clear the defect next
नंबर 9
yes record was called material with regard to exemption application said to have been filed by the petitioner under section 20 of the urban land sealing regulation.
Well, its record is available with us, my lords. So it will
But
be,
this particular record is available.
yes, my lord. We have called original record of it.
It will be 2 my lord instead of 20.
The application was under 2Q of the Act.
Sir, 2Q. Now section 20 limits.
Because 20 otherwise also provided for exemption. Like for agricultural
Is urban.
So my lords kindly keep.
I just go through the record and I will have to the matter.
TVS में लिखे in compliance with order dated 24/8/23, the record is available. Original record
Yes, sir.
is available. Learned counsel for respondent press for time to go through the record and argue the matter list after 4 weeks.
सेक्शन 24 की एप्लीकेशन पर इंक्रीमेंट इन रिप्लाई देना है 24 की एप्लीकेशन फाइल की इसमें मिलट
आपको काम में नहीं है,
मैं दे देता हूँ मैं
उसमें जो दिया गया है
मैं दे देता हूँ
ये फर्स्ट अपील मेंटेनेबल होगी तो इसके
नहीं फर्स्ट अपील तो अगेंस्ट 13 के आर्डर के अगेंस्ट है जजमेंट के उसमें हमने
उसमें एप्लीकेशन लगाई लो तो फाइल करिए एफिडेविट दोनों पार्टी करेगी क्या,
दोनों को करना पड़ेगा
है ना?
दोनों को
देखिए इन व्यू ऑफ द जजमेंट ऑफ द अपेक्स कोर्ट इन द केस ऑफ रजनीश नेहा वर्सेस नेहा पेटिशन डाल the parties are directed to file the proper affidavit list after 2 weeks. हाँ reply दे दीजिए आप 2 weeks time to file reply to IA section 24 हाँ और applicant को direct कर दीजिए to file affidavit रजनीश ने ऐसा बोला. Yes, next number 11
डिसमिस किया है ट्रैक कंडोनेशन ऑफ डेलीगेटेड नोट ड्राइवर डिसमिस किया है मैंने तो कंडोनेशन फर्स्ट अपील है
कंडोनेशन कितना डिले
76 डेज
आइए कंडोनेशन अलाउ कर दीजिए इसको एडमिट इशू नोटिस पीएफ रिटर्नेबल और फॉर द रिकॉर्ड्स नेक्स्ट
temporary suspension also on the ground of present applicant's wife lordship.
प्रेजेंट एप्लीकेंट्स
Right, sir.
भाई क्या हो गया
और उसको सब abdominal
वेरिफिकेशन हो गया
नहीं सर टुडे इज लिस्टेड फर्स्ट टाइम
इसमें आईए नंबर 209624 एप्लीकेशन फॉर टेम्पररी सस्पेंशन ऑफ सेंटेंस ऑन द ग्राउंड ऑफ wife illness
वाइफ से
has been filed at the factum of wife's illness be got verified by the competent authority. Your jail doctor. Report in this regard be submitted within 1 week. 2 weeks.
सर हॉस्पिटल है अभी हॉस्पिटल से
2 weeks. 2 weeks.
सर
Just in the last
करना है इसलिए
4th.
सॉरी
Yes, next. Number 13.
Please, my lords. My lords, this is an appeal against the order of the learned single bench. Wherein, my lords, the learned single bench is dismissed by writ petition on the ground that the facts, my lords, may I read the improved order at page 35?
Yes.
All the second last paragraph, my lords, all the facts and grounds mentioned in the writ petition are not liable to be examined in the writ petition filed under section Article 226 of the Constitution of India. Now, my lords, I'll pause here for a moment, my lords. I'm not challenging the facts, my lords. I am here that the sub-divisional magistrate ought not to have registered the deeds of assent, my lords. Why I'm saying this, my lords, it is the document which has been registered is illegal, my lords. The deeds of assent, my lords, as per the Indian Succession Act.
cancel the deeds of assent.
Please, my lords. Because the sub-registrar, my lords,
Deed of mortgage. Can we quote all these things in writ petition?
these, my lords, if that is illegal, if the document registered is illegal, my lords, then it can be caused, my lords. My lords, there is a judgment of Honorable Supreme Court in Veena Singh. This is District Registrar.
ये तो will है ना?
These ballots. There was a will, my lords, and as per the will, deeds of assent were to be issued, my lords. The very co-executors, my lords. My lords, may kindly directly come to page number 24 of the judgment, my lords, para 39. Mary, my lords.
39.
Please, my lords, page 24, para 39. Married?
Yes.
In the event of a refusal by the registrar, a suit can be filed by a party in terms of provisions of section 77 before a civil court, praying for a decree directing the document to be registered. On the other hand, an order of the registrar directing the registration of a document is amenable to a challenge under 26 of the Constitution. While seeking a writ of certiorari, the person moving the petition before the High Court would be entitled to establish whether the registration has been ordered in breach of the statutory provisions and is contrary to the law, my lords. Now, my lords, I'll just go to the bill, my lords, for one moment.
Mere existence of a remedy available for the civil court under section 9 CPC to avoid will not divest a person
Who come?
undoubtedly whether a writ should be entertained lies at the discretion of the court, and in a given case the High Court may decline to do so on the ground that disputed questions of facts are
That's, my lords, not question of law. Here I am here because, my lords, there is a question of law involved. And that has to be adjudicated by my lords.
duly fulfilled. So what is wrong? Why these deeds of assent should not have been registered?
I will come into that, my lords. My lords, respondent number one was not only the co-executor, because there were multiple co-executors to the will, my lords. For that, my lords, there is another Supreme Court judgment that one of the executor cannot grant deed of assent in favor of the legatees. First point is this, my lords.
ठीक है, issue notice.
Please, my lords.
Notice here. Next.
Termination matter, petitioner was appointed as a Gram Rozgar Sahayak, my lord. And because some misappropriation of fund was alleged against him, my lord, when inquiry was conducted against him, first initially the SCN was issued, then he filed the reply, then inquiry was conducted, and after the inquiry, the charges were found proved, my lord, and on the basis of that inquiry, he was the impugned order of termination was passed against the petitioner. My lord, against that, my lord, we challenged the same by way of filing the writ petition, my lord. The writ petition was allowed, my lord, stating that no inquiry was conducted, and therefore, my lord, since the impugned order was
Hearing was not granted.
my lord. But my lord, in this matter, this is not the matter where chance of inquiry, chance of hearing is not given to the petitioner, my lord. If my lord may kindly say,
Inquiry has to be conducted.
yes, my lord, the inquiry has been conducted. That is, my lord,
That is ex parte inquiry without issuing notice to the petitioner.
my lord, the notice has been issued to the petitioner. P5 is the
Charge sheet.
my lord, it is not provided in the appointment order. If my lord may kindly see the P1, my lord, is the
No, even if it is a
P3, my lord, is the appointment.
not a confirmed employee, then also
But my lord, kindly see the P3, my lord, which they have filed, the appointment order. Clause 15 of
under stigmatic है ना? जहाँ stigmatic वहाँ inquiry proper opportunity सब देना जरूरी है.
My lord, everything was given, my lord. SCN was issued to the petitioner.
बताइए गंदावन क्या procedure adopt किया आपने?
My lord, first, I just want to show the, my lord, annexure P3, my lord, is the appointment order. I just want to show that what is the, how they can remove from the citizen.
Page 21.
Page 21, my lord. P3, my lord. This is the appointment order, my lord. Clause 15 of second page, my lord. Clause 15. संविदा पर नियुक्त व्यक्ति के कदाचार या किसी आपराधिक क्रियाकलाप में संलिप्त पाए जाने पर नियुक्ति प्राधिकारी उसे सुनवाई का युक्तियुक्त अवसर देने के पश्चात ऐसी संविदा नियुक्ति समाप्त कर सकेगा. This is provided, my lord. Now, my lord, kindly see the
नहीं, फिर भी इंक्वायरी करना जरूरी है.
yes, my lord. The inquiry has been conducted, my lord. I just
show us the show cause.
yes, yes, sir. P5, my lord, is the SCM, my lord.
P5
Page number 26, my lord.
10/9/2022 किसको दिया ये?
My lord, the petitioner, my lord.
ठीक है, फिर उसके बाद
After, my lord, we filed the reply to this SCM, my lord, this is at page number 29, P6. And thereafter, my lord, a committee of 3 officers has been constituted, my lord, comprising of CEO, Janpat Panchayat, and my lord, that inquiry report is at the reply, my lord. R2. Page 16 of the reply. मुख्य कार्यपालन अधिकारी जनपद पंचायत सेंधवा, नायब तहसीलदार तहसील वरला, ब्लॉक समन्वयक आवास जनपद पंचायत सेंधवा. The officers
जांच प्रतिवेदन है, ये ब्लाइंड डिबैट कंडक्ट हुई है.
but my lord, the SCN has been issued. The reply,
Where's the law? लॉ बताओ, ये SCM देने से टर्मिनेट कर सकते हैं आप.
my lord, but the appointment.
सिक्योरिटी की नौकरी चलेगी उसकी, आप उसको मौका तो देते, चार्जशीट इशू करते, चार्जेस फ्रेम करते, प्रॉपर इंक्वायरी कंडक्ट होती रूल 14 में.
My lord, he was appointed only on the contractual.
Even then there are judgments to that effect. It's not termination simply sitter on the ground that his work is not satisfactory.
My lord, this is not the allegation, my lord. Allegation is misapplication of the.
Misappropriation मतलब stigmatic order. So he is required to give the opportunity, or the inquiry is necessary in that case. Judgment देखी नहीं ना आपने, देखना
I saw the judgment on that. My lord, that is distinguishable, my lord, because in those cases, my lord, no inquiry was conducted and he was.
इंक्वायरी आप ऐसे डाल दे, आप ही आपस में इंक्वायरी कर लिए, उसको तो पता ही नहीं क्या हुआ अंदर इंक्वायरी के. उसको मौका तो मिलता सामने आने का.
Earlier SCN was issued. Before inquiry, SCN.
Only SCM will not do. कई जजमेंट्स हैं, 311 आर्टिकल वो भी है, वो सब रहता है. ठीक है, ऑर्डर भाई बिल्कुल सही है. He has to be reinstated और लिबर्टी दी है आपको, फिर से प्रोसीड करो.
Yes, sir.
In accordance with law, you follow the procedure. Remove him again. Yes, ठीक है, इसमें dismissed. Next. जरूरी देखो, जजमेंट निकाल लेना, लगा देंगे उसमें.
Item number 15. Requires 5. Item number 15.1 to 15.14, they have to file a reply. Ultra virus.
These are challenging the virus of the amendment made in Nagpur Gram Nivesh Adhiniyam. So virtually they can adopt the reply in 15.1 because the reply will remain the same, the grounds are same.
So why do you need to file separate reply? Issue is same. You can adopt.
But state reply is also must.
Statement जरूरी.
2 weeks time, my lord.
इसमें लिखिए, इसमें आपका लिखा था कि you will adopt the reply.
No, my instructions से नहीं पड़ेगी idea.
और इसमें लिखिए, Leonard Council press for time to
4 weeks time, my lord.
4 weeks time to file reply.
2 weeks may be sufficient.
नहीं होगा, नहीं थोड़ी है, इतनी जल्दी थोड़ी होगा.
I will not having stay there for having a rush. I will not having stay there for having a rush.
ठीक है, वायरस का मैटर है.
No, they are carrying out the development of the scheme. So,
ठीक है, एक 4 weeks में आप फाइल करिए, आपको भी फाइल करना है, you can also file. Next slide.
Under item number 16, I am paying for 2 weeks time, certain clarifications to be obtained from the department.
So इसमें लिखिए, Leonard Council for appellant pays for and granted 2 weeks time to argue the appeal.
17 minor matter pertains to section 263 minor. Assessment was completed on the returned income shown by the assessee. And later on, AO observed that there was cash deposit of rupees 3 crore 19 lakhs, which was not considered by the AO, and therefore CIT appeal quashed the order under section 263 and directed the AO for making fresh adjudication. Tribunal the later on 263 order was challenged by the assessee before the tribunal. Tribunal allowed the ruling of the assessee by holding that there is no specified nature and manner was not shown. It is not required. Page number 11 is very much correct. AO was directed to see and examine that particular transaction, and for the purpose, earlier also, this Honorable Court was kind enough in considering the powers of CIT that proper inquiry was to be done by the AO, and if it was not done properly, then CIT under section 263 is competent to direct the AO to pass appropriate order after considering the direction of the CIT appeal, my lord. That is ITA number 210 of 22. Page number 32 and 33. CIT has observed, and at page number 11, cash deposit of rupees, page number 11, 3 crore 19 lakhs was not shown, and therefore CIT directed a fresh assessment by that. And the Honorable Apex Court, in the case of Winley, has held that AO CIT appeal is competent to examine the matter.
नहीं, आपने कोई ऐसा एलिगेशन लगाया कि जो AO ने जो असेसमेंट किया that lacks bona fides.
मैंने AO ने हम AO का आर्डर बताते, इन्होंने रिटर्न इनकम का एज इट इज एक्सेप्ट कर लिया.
जजमेंट है ना इसमें.
मैंने अपेक्स कोर्ट का जजमेंट में लेके आई हूँ. CIT अपील पर 263 में पूरे पावर है कि अगर AO ने कोई गलती किया है.
The fact remains that the specific issue raised in the revision order was specifically looked into, detailed submissions were made, and these submissions were duly accepted by the assessing officer.
Yes, ma'am.
Merely because the assessing officer did not write specific reasons for accepting the explanation of the assessee cannot be reason enough to invoke the powers under section 263.
Yes, madam.
And non-mentioning of these reasons do not render the assessment order erroneous and prejudicial to the interest of the remedy.
Yes, madam. हम CIT का पावर देखते हैं. That is at page number 32 and 33. CIT ने जब बैंक का डाटा बुलाया, पेज नंबर 11 पे 3 करोड़ 19 lakhs वे कैश डिपॉजिट, तो ये एस्पेक्ट चूंकि एओ ने नहीं देखा था, तो उन्होंने कहा कि वापस आप डिनोवो असेसमेंट करेंगे और इस इशू को देखेंगे. तो क्लियर कट ऑर्डर है कि आपको ये देखना है और स्पेसिफिक डायरेक्शन की जरूरत नहीं. At page number 19, last paragraph. As per the SFT details obtained from the bank by the department. On record, it was observed that during that total cash deposit of rupees 3 crore 19 lakhs in bank account of UCO Bank, which was deposited during the demonetization period. However, the perusal of cash book provides that assessing claimed the only cash deposit of rupees 1 crore, and therefore this direction was given to. It is very specific and particular. And accordingly, question of law have been framed.
The ITAT relying on the judgment of the Supreme Court,
yes,
they have come to the conclusion.
My lord, अब हम लोग under an apex court पे, under the apex court in the case of Binlay, हमने recent judgment में held किया है कि CI जहाँ भी revenue का 263 में erroneous as well as prejudicial to the interest of the revenue. जहाँ पर revenue का interest किसी भी कारण से डिफीट हो रहा है, तो CIT उस असेसमेंट को रिकॉर्ड को देख के एप्रोप्रिएट डायरेक्शन देगा. यहाँ पर उन्होंने 5 लाख का रिटर्न बताया, एज इट इज एक्सेप्ट हो गया. तो नो इंक्वायरी वाज कंडक्टेड एंड देयरफॉर CIT डायरेक्टेड और ट्राइब्यूनल ने केवल इतना कहा कि स्पेसिफिक मैनर नहीं है, स्पेसिफिक मैनर 32-33 पे है कि आपको क्या देखना है और आपने क्या नहीं देखा है, और स्पेसिफिक की जरूरत नहीं है। तो विनले ये रिसेंट जजमेंट में ऑनरेबल अपेक्स कोर्ट ने कहा है कि सीआईटी वाज जस्टिफाइड इन पासिंग द ऑर्डर अंडर सेक्शन 263 फॉर फ्रेश ऑर्डर फॉर कंप्लीटिंग द फ्रेश असेसमेंट ऑर्डर मैटर।
How it is erroneous and prejudicial बताइए।
Yes, my dad. 3,19,00,000. Yes, my dad.
It is erroneous.
Yes, my dad. ऑर्डर इसलिए गलत है कि आपने रिटर्न इनकम को एज इट इज एक्सेप्ट कर लिया। तो जो हमको बाद में खबर मिला कि यूको बैंक में आपने 3,19,00,000 रुपए कैश डिपॉजिट किया, तो वो कहाँ से आया? उस पर चूंकि टैक्सेशन नहीं हुआ है, इरोनियसली और प्रीजुडिशियल टू द इंटरेस्ट ऑफ द रेवेन्यू भी, और उसी पावर को यूज करते हुए कमिश्नर ने डायरेक्शन दिया, और वो है पेज नंबर 11 पे। माइनर पेज नंबर 11 पे लास्ट पैरा देखेंगे, पेज नंबर 11, एज पर द एसएफटी डिटेल्स, जो बैंक से डाटा कलेक्ट किया गया वहां पर ये पाया, ड्यूरिंग द ईयर अंडर कंसिडरेशन टोटल कैश डिपॉजिट्स ऑफ ₹3,19,00,000 इन बैंक अकाउंट ऑफ यूको बैंक, which rupees such and such 75 lakhs was deposited। तो इन्होंने 1,81,00,000 का ही हिसाब दिया।
इसको पढ़ के करेंगे।
Therefore, considering the judgment of honorable apex court,
चेक होगा। तो आपके केस में कैश डिपॉजिट हुआ है,
कैश डिपॉजिट हुआ है, और उसमें भी केवल
उसका कोई टैक्स भरा नहीं उन्होंने।
नहीं, और इसी लाइन में ऑनरेबल दिस ऑनरेबल कोर्ट हैज एडमिटेड माय अपील
दिखाइए।
इन आईटी नंबर 210। तो 263 में अब कमिश्नर को ये पावर है कि अगर प्रॉपर इंक्वायरी नहीं हुआ है तो आप देखें उसको।
ठीक है, ये नहीं तो इसमें डिले है।
हाँ माय डैड, इसमें डिले है, माय 1 डेज डिले माय डैड,
1 डे डिले
माय डैड 1 डेज।
तो आप अपील एक दिन में बना लेती है, इसमें वहाँ पे आकृति में इन लोग।
हाँ मैंने एक ही दिन में 3 अपीलें तैयार किए, और उसमें
इनकम टैक्स डिपार्टमेंट लास्ट डे पहुंचता है,
लास्ट डे मैंने
24 घंटे भी कम पड़ जाते
तो मैंने अपना हेल्पर प्रीमाइसेस में
हैं। 25 अपील लेके आगे मेरा तो इट वाज इम्पॉसिबल, डिले तो होना ही है।
मैंने नवंबर और दिसंबर में 200 अपीलें फाइल की कि वो एक साथ वो।
ठीक है, इसमें हेड एंड आईए 1337/24 application for condonation of delay for the reasons stated application allowed delay of 1 day in filing the appeal is hereby condoned। ये सेम
क्वेश्चन ऑफ लॉ
आईडी नंबर 210/22। चलिए नेक्स्ट
सेकंड मैंने इसमें पेज नंबर 42 पे IT नहीं, रिलायंस प्लेस किया है आइडिया सेल्यूलर पे मैंने, वो तीनों अपीलें फाइल हो गई है। ITA नंबर 16023, 16223 और 16723 मैडम
लिस्ट अलॉन्ग विथ।
हाँ मैडम, और वेरी सेम टाइम ये इशू ऑनरेबल अपेक्स कोर्ट में हर्ड हो गया है, रिजर्व फॉर ऑर्डर है, ऑर्डर
नेक्स्ट डेट पे करेंगे, देख लो रिजर्व फॉर ऑर्डर है ना।
हाँ मैडम, हर्ड 6/11 को हर्ड हुआ है।
ठीक है, इसमें लिखिए लिस्ट दिस केस, लिस्ट दिस अपील अलॉन्ग विद PTA नंबर 16023, 16223, 16323 आफ्टर 4 वीक्स।
167 मैडम,
167
हाँ 167
163 की जगह
यस मैडम,
आफ्टर 4 वीक्स है ना।
आफ्टर
So that if that case is decided, खत्म हो जाएगा।
बिल्कुल
Yes,
मैडम।
next।
यही ऑर्डर मैडम आइटम नंबर 51 में भी जाएगा। इसी का आइडिया सेल्यूलर का एक और केस वो 51 नंबर पे लगा है, ये भी वही ऑर्डर इसमें भी जाए 51 पे मैडम, भारतीय एयरटेल आइडिया सेल्यूलर।
ठीक है, इसको भी लिस्ट along with
I नाम बिल्कुल चेक करो।
next number 19.
और लास्ट का
This is an appeal by the system. I'm making a very innocuous prayer, madam. The appeal order is election, in page number 16. Madam, reliance has been placed on SR Feroz case. That matter is pending in Supreme Court. This is the order sheet, madam. It is likely to be finally disposed of on 19th of March. So, if my lord so pleases, madam, it may be adjourned. Orders of the Honorable Supreme Court may be awaited.
ये जो SR फेरो वाला है,
जी,
इसके बेसिस पे उसको डिस्पोज ऑफ किया।
डिस्पोज ऑफ किया सर। उसके बाद हमने एसआर फेरो में रिट अपील फाइल की, वो भी डिस्पोज ऑफ हो गई। उसके अगेंस्ट सुप्रीम कोर्ट में एसएलपी पेंडिंग है सर, 19 तारीख को फाइनल डिस्पोजल है। तो उसके बाद सर इस मैटर को
इसमें द learned counsel for appellant submitted that the writ petition has been decided on the basis of judgment passed in the case of Messrs. SR Ferro alias bracket में FAD bracket close versus MP पश्चिम क्षेत्र विद्युत वितरण कंपनी लिमिटेड भोपाल एंड नगर WB number 26921/22. Instead the appellants are preferred in SLP.
Yes, sir.
In Supreme Court SLP number 1030/24 before the Supreme Court, which is likely to come up for final disposal on 19/3/24. The result of this writ appeal shall be governed by the order passed in SLP. Therefore, the matter may be adjourned list after 4 weeks.
They may be directed, my lord, to supply me the copy of the writ petition and the annexes, my lord, because no notice was issued for me. So you are
List after 4 weeks.
Number 20.
Yes.
मैडम एनसीसी फॉर रिस्टोरेशन मैडम
ये WA है, ये रिट अपील है 20 नंबर।
20 नंबर
After number 21 score. Yes.
Lordship, we have filed an MA against the section 10 of guardianship and
Guardians of Wildlife.
Lordship, in this, the learned trial court has given in the judgment an ex parte. We haven't received any notice and it was not served. So it was an ex parte and learned trial court continuously asking us to, if we may file this MA, then they are asking that if you can just take this stay, otherwise you have to.
Why didn't you appear? If you want to, you want to appear.
Yes,
Last time you didn't appear.
Sir, last time I have put this mention memo on 12th of February. It was listed on 12th of February.
अरे भाई जब केस फाइल होने के बाद में जब लगा कोर्ट में तो आप अपीयर नहीं हुए, नन फॉर द अपील लिखा हुआ है।
One time it was happened, that's why we have changed the counsel. Like party has changed the counsel and I appeared.
नहीं तेरा क्यों नहीं लगाई आपने?
Sir,
नहीं तेरा क्यों नहीं लगाई? सेटिंग असाइड एक्स पार्टी डिग्री
right, sir.
क्यों नहीं लगाई आपने? तो लगाइए फिर आइए यहाँ पे।
Actually, sir, they are asking, the land trial court is asking.
We are not going to grant you any stay today.
Sir,
It is in file 913 is there. There is a provision under the CPC.
अच्छा.
अभी भी आप जाके फाइल करिए, सेट असाइड कराइए उसको।
Sir, actually, this is the last chance and this case was handed over at the time of hearing.
Your grievance is that the lower court, without hearing you, passed an ex parte decree. So there is a provision, if you see order 9 rule 13 CPC. क्या है मालूम है आपको वो?
जी सर, वो वहाँ पर हम उसको अपील कर सकते हैं, वो जो ऑर्डर वहाँ हुआ उसके अगेंस्ट हम बाय पार्टी के लिए आवेदन कर सकते हैं।
Recalling of the ex parte decree.
Yes, yes, ma'am.
Not by party. वो लगाइए, उसके बाद आइए, वो हो सकता है रिकॉल कर ले।
So, my lord, my humble submission is that at least this time, just put grant us this thing so that we cannot hand over, otherwise एक बार सर अगर कस्टडी चली जाएगी then
So we dispose of with the liberty to approach and file an application 913, and limitation will not come in your way because we have You have wasted your time here before the High Court. इतना कर देंगे बस हो गया.
लॉर्डशिप बस इतना सब मेरा एक हम्बल रिक्वेस्ट है कि वो
पिटीशन एंटरटेन नहीं करते तो नहीं इंटरव्यू. सिंपल.
But Mano, 24th of February this week, we have the hearing there, and they are asking us because they will file on contempt. So that is my humble request. It is
एग्जीक्यूशन आएगा कंटेम्प्ट के खिलाफ. अभी कुछ नहीं होने वाला है. यू फाइल 930.
they are asking to hand over the kid, sir. वो kid को सर ने खुद 2 मिनट के लिए मिलने बुलाया था. He is not even recognized them.
ask for a stay there only with the application. इसमें लिखे this after arguing for some time, if you are disposed to withdraw this appeal with the liberty to file application under order 9/13 CBC before the trial court. Full stop. If such an application is filed within 7 days, then the question of limitation shall not come in the way of deciding the aforesaid application with the aforesaid liberty. This writ appeal is dismissed as withdrawn.
Yes, my lord, pleading has been completed in this matter. My lord, the issue involved in that, I have been arrested by the police. Along with the, one of the allegation is fraudulent taking the refund of the IGST.
What is the urgency in this case?
Please, my
Is there any urgency?
my lord,
I should hear it out of 10. This is a 2023 petition.
my lord,
Leaders are complete. We'll admit and fix for final hearing.
my lord, they just conduct the inquiry after arresting me. That is the urgency, my lord, in this case.
What is your prayer in this
The
petition?
petition is entirely misconceived. We are investigating a case where anticipatory bail application has been rejected by coordinate bench, honorable single bench, my lord. Now they have filed this petition invoking Article 20 subclause 2, saying that state police crime branch was investigating some matter in which there was some portion relating to
Yes, my lord. My lord, because the state police has moved the cancellation of bail on the ground that because they have not paid the IGST amount which is just refunded to them. My lord, how for one offense, the police has already conducted the inquiry, FIR has been filed.
These are entirely different. Bail मिल गए उनको. Sir, ये क्यों anticipatory bail? Offenses are entirely different. That was filed by some checking time under section 420, 467, 468, 471.
But for the same offense,
Sir, ये पहले अपनी Sir, this I am carrying a shadow file. I am carrying a shadow file that would demonstrate that it is entirely different offenses. Entire petition
there is a no different kind of offense. What is this, my lord? The GST bring into the with the one and only purpose to just going to remove the effect of cascading effect of the taxation at each and every stage of the purchase or
Hearing finally, please not today, not today. Just immediately if petition is admitted for hearing with this, when do you want?
25th.
Not this month, next month.
Just the 1st of March.
Friday is not possible. You can
5th, madam.
Fifth. With this case, admitted this case in the final hearing list on 5th of March 2024.
Meanwhile, then the stay application I will allow.
No reversive action. That cannot be granted in this petition. Your 438 has already been.
Yes, ma'am. It has been read. The Supreme Court say that in the
Is that rejection of whole idea?
CGST in CGST.
Let's say the Supreme Court says no bail can be granted.
Yes.
Or no coercive action orders can be passed.
Yes. No, my lord.
Now, are you aware of that?
Allow me.
Please, are you aware of the Supreme Court judgment or not?
Niharika, I'm just aware about that. Thereafter that in CGST case,
Wherever it is, bail cannot be granted in a writ petition.
But Justice Patiwala has recently passed the order. Anti-party bail is not
Additional
available in the case of the CGST after the
in challenging that rejection of 430 application. Have you challenged that?
No matter what, because the Honorable Supreme Court has given regarding the entire action,
That will also amount to grant bail. Yes, as good as granting bail. Yes. And that was what Supreme Court says.
the Supreme Court has extremely bad that for a moment kindly see that judgment. They have said that if there is a no anticipatory bail,
We are waiting on an application for entry. Okay. लाइए, judgment लाइए. Shows the judgment, recent judgment of the Supreme Court. All together.
under para 16.
What was challenged in this SLP?
This is SLP, they have moved the writ petition. Thereafter, the Gujarat High Court has not entertained that. Thereafter, that has been challenged. And the para 16 matter. Thus, the position of law is that, third page of para 16. If any person is summoned under section 69 of CGST Act 2017 for the purpose of recording of this statement, the provision of section 438 of the Criminal Procedure Code 98 cannot be invoked. We say so as no first information report gets registered before the power to arrest under 69 of the CGST Act 2017 is invoked. And in such circumstances, the person summoned cannot be invoked section 438 of the Code of Criminal Procedure for anticipatory bail. The only way a person summoned can be seek protection against the pre-trial arrest has to be invoked the jurisdiction of the High Court under 226 of Constitution of India. Undoubtedly, this is exactly what the respondent did in the present case. What the respondent sought by filing two criminal applications under 226 of the Constitution before this Honorable Court was the direction of the appellant herein not to arrest them in exercise of the power, not to arrest them under section 69 of CGST Act, thus in existence the key to pay anticipatory bail. However, we have explained aforesaid at the stage of summons, the person summoned cannot be invoked section 438 of the Code of Criminal Procedure, madam.
No FIR registered against you.
In GST, they have not registered any FIR. We have not registered FIR.
This is a conditional order in case there is no FIR. Well, only.
But if in reference of GST, because the CGST, they have not done power.
We say so.
They have already arrested me. They have arrested.
Continuous question, you are not answering that.
Please, madam.
Third line says, we say so as no first information report gets registered.
Please,
So in your case, whether there is any first information report.
That is my case, madam. They have registered the first information report, FIR. Thereafter arrested me. I was in police remand for 13 days.
Yes.
They have conducted all kind of inquiries, sir. You are challenging all kinds of things.
This petition, you are challenging that FIR.
No, madam, I'm challenging the CGST action.
No, then you have to get the FIR quashed first. In that case. You can ask for such care. FIR will remain as it is, even though it is wrongly registered, according to you. You will be there.
No, madam, it's maybe I'm not able to explain.
FIR registered, yes or no?
FIR registered by police. Eventually taken the IGST by
At least one by one, we will go step by step.
Please,
FIR registered.
please, madam.
So this relief cannot be granted.
I was arrested in that FIR, madam. I was arrested in that FIR. Then the court has sent me 13 days police remand. During the remand, police conducted all the inquiry, collect all the documents, seize, conducting all kind of seizure. They have filed the charge sheet. In that case, I got the bail from this honorable court. After getting the bail, the CGST has said that, you know, now I'm just going to get the inquiry. All the police has collected all the documents. So regarding that,
We are on bail as on date.
yes, I am on bail on, in date, my lord.
क्या इंटरव्यू का चाहिए?
सर मैं बताऊं, बिल्कुल एब्सोल्युटली मिसकंसीव्ड पिटिशन. बेसिक फैक्ट्स ये हैं सर कि सर दिस इज अ शैडो फाइल, वी आर बिकॉज़ वी आर नॉट
Clarified, we are hearing on entry.
सर सर इवन एंट्री
38 has been granted.
no sir, it has been rejected. Sir 430
in that order.
sir, that is page number 105 of this petition.
But he says it has been granted.
Sir, it has been granted for
My lord, I got the
sir, I did not interrupt him, I expect the same first. Please. Sir, there are two separate
Confused. Come to the point straight.
and
Whether FIR lodged or not, you say yes. Bail मिलेगी नहीं.
सर हमारे केस में पेज नंबर 105 पे इनकी पिटिशन 438 रिजेक्टेड बाय डिटेल्ड ऑर्डर.
नहीं, but then what happened? 439 भी तो
सर बिल्कुल एब्सोल्यूट सर पूरी बात मैं 2 मिनट में बताऊंगा. सर पेज नंबर 105 इनकी पिटिशन. सर बड़ा अलग अलग केस है. एक केस रजिस्टर किया क्राइम ब्रांच स्टेट ऑफ मध्य प्रदेश ने, वो किया 420 67 68 71 में. सर
क्राइम नंबर बताइए, किस क्राइम नंबर?
सर ये जो क्राइम नंबर से हमारा जो था वो है फाइल नंबर F/प्रिवेंटिव/2324. ये सर उसकी रिपोर्ट. ये 4 जुलाई 2023 का ऑर्डर है सर. इसमें सर रिजेक्ट हुई. उन्होंने ऑर्डर ही फाइल किया, इन्होंने वो रिपोर्ट्स में जो हुआ वो फाइल किया. पेज नंबर 105 से शुरू हो रहा है सर, 107 पे कंक्लूड हो रहा है सर.
ये एमसीआरसी कार की लिए थी.
सर ये एमसीआरसी थी, प्रोटेक्टिव ऑर्डर पे हमारे केस में सर.
This was not a 438 application.
ये इट वाज 438 सर. वो 438 एप्लीकेशन. ये उसके पहले एप्लीकेशन है ना सर, आप एप्लीकेशन देखो. सर ये एप्लीकेशन शुरू हो रही है पेज नंबर 79 से, पेज नंबर 7 से सर, पेज नंबर 85 से सर. फर्स्ट एप्लीकेशन अंडर सेक्शन 438. ये इनकी एप्लीकेशन थी सर,
ऑर्डर हुआ.
जिस पे ऑर्डर हुआ 438 की रिजेक्ट हो गई. सर ये जिस 439 की बात कर रहे हैं वो क्राइम ब्रांच स्टेट ऑफ मध्य प्रदेश में
This is
बाय जीएसटी
crime number 23 of
23 और जीएसटी सर.
23 of कहाँ लिखा था मेरे को?
फिर हमारे यहाँ क्राइम नंबर नहीं होता, फाइल नंबर है सर. हमारे फाइल नंबर है सर
23
सर. इसमें ये रिजेक्टेड है सर
23/23.
सर. ठीक है.
हाँ, ये रिजेक्ट हो गया.
रिजेक्ट हो गई सर.
आप 439 का ऑर्डर बताइए.
सर 439 का ऑर्डर, इनका जो 439 का ऑर्डर हमारे केस में तो अभी अरेस्ट ही नहीं हुआ, स्टैंडिंग है. 439 का ऑर्डर है सर, वो है स्टेट ऑफ मध्य प्रदेश ने कोई इनको अरेस्ट किया, स्टेट ऑफ मध्य प्रदेश के क्राइम ब्रांच में कोई इनको अरेस्ट किया उसके केस में.
In connection with this case number
नहीं सर, इस केस में
23.
नहीं सर, वो अलग है सर. हमारा ऑर्डर सर वो ऑर्डर है पेज नंबर 4900. उसमें सर आप देखेंगे ये क्राइम नंबर 23 अलग है सर. स्टेट का क्राइम नंबर ना 23, हमारा तो फाइल नंबर है सर. सर पेज नंबर 50 पे है सर.
Page 50, FIR at page 48 is the relevant portion for that matter.
Why don't you allow him to come?
Yes, please, sorry, ma'am. Sorry, ma'am.
सर ये स्टेट ऑफ मध्य प्रदेश क्राइम ब्रांच ने एक शिपिंग लाइन की एफआईआर रिपोर्ट
54 annexure PC
ये 44 है. ये हमारी एफआईआर नहीं है, ये स्टेट ऑफ मध्य प्रदेश क्राइम ब्रांच की एफआईआर है सर. उन्होंने एक शिपिंग लाइन के कंप्लेंट के बेसिस पे सेक्शन
लाइन नंबर 23 और 24
सर इनका 23 हमारा तो सर ये फाइल नंबर 5 है सर. हमारा है 5 ये सर हमारा टाइम नंबर है 5/23-24. दिस इज आवर केस फाइल सर. तो इनको जो अरेस्ट किया गया वो पुलिस क्राइम ब्रांच स्टेट ऑफ मध्य प्रदेश के एक केस में 420, 467, 468, 471 में एक शिपिंग लाइन ने इनके अगेंस्ट एफआईआर लॉन्च की. उसमें ही वाज अरेस्टेड. During course of investigation, crime branch found certain things related to
crime number 23/23 लिखा हुआ है.
इसमें सर
नंबर 54.
नहीं सर हमारा केस अलग है सर, हमारा केस अलग है सर. हमारा तो पूरा केस ही अलग है.
ये 439 की एप्लीकेशन 23 से रिलेटेड है हमारा जब आपको बिल मिल चुकी है तो फिर why are you asking for an interim relief or no coercive action?
May I,
According to you, you have 439 में आपको बिल मिल चुकी है.
please, madam.
तो then why interim relief you are asking now in this case?
The same offense, now the CGST has started the inquiry and want to arrest me. For the same offense, for a moment, kindly see.
Same offense ना वहाँ बिल मिल चुकी है आपको. You want further interim order from this court? Tell us how it is different from that.
According to me, there is a same offense, madam. I'm not going to put in.
Let them violate. If they violate, file a contempt. Sir, केस दोनों ऑफिस अलग है. वो चीज कर रहे हैं कुछ नहीं. सर मैं सिंपल सर एक्सीडेंट ये वाला जी कि सर ये हमको अरेस्ट कर रहा है फलाने क्राइम नंबर में. अगर सेम क्राइम नंबर में बिल मिल चुकी है तो वाई वांट्स नॉन नो कोर्सिव एक्शन. नंबर अलग है सर. क्राइम नंबर अलग है. दोनों इंस्टीट्यूट्स अलग है. वो क्राइम ब्रांच है सर. क्राइम ब्रांच स्टेट पुलिस अलग है. उसके केस में 439 मिली. अपने केस में 438 रिजेक्ट हो गई. हमारा केस बिल्कुल अलग फुटिंग्स पे है. हमारा केस है फेक इनपुट क्रेडिट बाय क्रिएटिंग फेक फॉर्म्स. वो एक शिपिंग लाइन का केस था. उससे और हमारा केस बिल्कुल अलग है. और सर मैं बहुत सिंपल सी बात कहता हूँ. हमारा केस फाइल नंबर लिखा है इसमें 5/so इसमें 438 रिजेक्ट हो गया. रिजेक्ट हो गया सर. उसके बाद से एब्सकॉन्डिंग 439 मिली. टाइम था 23 और
दोनों इशू सेम है.
अरे मिस्टर issue may be same, 100% it may be same, but the question is crime numbers are different.
Crime numbers are.
Cases are registered separately. So you cannot club 439 with this. You are wrong with facts.
Madam, my argument is
This file number rejected under 438. Why don't you file 439? तो एक्सपांड लेके 439 टाइप करेंगे. जी सुप्रीम कोर्ट जाइए उसके खिलाफ.
my case is that.
चलिए result you are not able to understand. I suppose once your 438 has been rejected, we cannot say anything in this case.
Yes.
And even in writ petition, no bail can be granted. चलिए result on interim relief, not final relief. Yes.
Final matter.
Final वो डेट दिया ना. इसी डेट तो 5 मार्च
only one line submission for a
ऑर्डर लिखा था क्या? अरे थोड़ा अंदर ही है उसको रहने दो. जी yes next.
One moment, one line submission before that. For a moment, kindly see page 48. 2 minute, madam. I'm not making
48 rejected in this case, but file number 5/so. Is it not?
yes, madam.
That is
The offense are same, madam.
we are not concerned. मैंने क्या बोला आपको 100 केस एक जैसे हो आपके. क्राइम नंबर अलग अलग है.
जैसे नहीं है मैडम. एक ही ऑफेंस के लिए 2 केस.
ठीक है तो ask for
जैसे नहीं है मैडम. there is a similarity.
you can file 482 for quashment of the similar issue.
There is they have filed under the CGST. How can I'm just going to challenge because they have not filed the complaint? They have started the inquiry. That is the reason I come before
this writ petition. Are you seeking quashment of that
inquiry? Yes, madam. This writ petition, I am seeking the inquiry, quashment of inquiry.
We will hear you finally on the next day. Then we were hearing you on the question of interim relief, which cannot be granted in the because 438 has been rejected in respect of the same inquiry.
Regarding that kind of my submission is that for if I have just filed the petition, it is a wrong remedy opted by me as per the direction of in the reference to the Supreme Court judgment.
Yes.
And even the Bombay High Court has in the writ petition being seen to handle
At the time of final, today we are on the question of interim relief. We are not answering the question.
I'm just going to on the interim relief. Why I am just pressing for the interim relief.
Please tell us.
Please.
438 rejected.
Yes,
Okay.
Regarding that
Same number. Same number. Yes, madam. Now, how can we grant you bail or no coercive action in this WP? What is the remedy of SNP against that 438? Or get arrested, then file 439. Two options are there. समझ रहे हैं आप कि नहीं समझ रहे?
yes, madam, I understand that.
Sorry, therefore rejected. Yes, next. आइटम नंबर 23 I am praying for adjournment also.
23.
क्या है? What is this? Late appeal?
No, WP, teacher eligibility test.
मेन बेंच पे जाइए। ये क्या मेन बेंच में जा प्रिंसिपल सीट पे जाएगा मैटर?
अटेंशन भी है रजिस्ट्री ने।
अरे आप बताओ ना, हमको तो सब चेक करना ही पड़ेगा, वो तो हम ही को देखना है पूरा। तो आगे खड़े हो जाए, अपना प्रेजेंस मार्क करा दो, बस हो गया। We'll see what is 15-20 मिनट इसी में देख रहे हैं कि यार रजिस्ट्री ने क्या बोला, इसने क्या बोला।
सर जी वो 2017 का था नोटिफिकेशन जो उन्होंने नोट किया, ये
मेरा असिस्टेंट हटाओ, खड़े हो गए, बस हमारा प्रेजेंस मार्क करो ताकि क्लाइंट को बोल देंगे कि हाँ गए थे हम। क्या है अगर why it is to go before the principal seat? List after 4 weeks, not able to answer. So the next.
24. I have a request to make in this case. These cases are when the borrower has broken the law and trespassed the property which forms the part of the secured assets. But I have filed 3 more cases. And there is one more which has already been filed. So may I request your lordship to fix all these matters on any date in the next week? I'll address your lordships.
No, मुझे लग रहा है ना वो एक बार प्रॉपर्टी हैंडओवर कर दिया, फिर बाद में उन्होंने ट्रेसपास किया। तो इनके पे बहुत सारे केसेस हैं।
लास्ट वीक आपको कुछ मैटर्स थे तो वो आपने आज लिस्ट करे थे, सारे टाइटल हो गए। अच्छा, और मैटर्स भी हैं सर जो मैंने आज फाइल किया है।
वो तो हो जाएंगे ना, इस पे बस करो ना, इसमें रिप्लाई आया किसी में? ये नोटिस किया था अभी?
वो अभी नोटिस नहीं हुआ है सर, किसी भी मैटर में नोटिस नहीं हुआ क्योंकि वो इट वाज
अभी कल हुआ ना, कल तो मंडे तब हुआ। तो हल्ड करके हल्ड कर दिए तो रिजर्व फॉर ऑर्डर। नहीं, वो सबने नोटिस कर दिया। ठीक है, इसमें भी नोटिस कर देते हैं, नोटिस करके उसी के साथ लगा देते हैं।
एड्रेस योर लॉर्डशिप्स ऑन दैट केस।
We have already issued notice. We cannot grant you any interim.
No, there can be any interim. There cannot be any interim.
But the issue notice PF returnable 4 weeks. और वो लिस्ट along with नंबर पूरे दे दिए साथ में।
Your lordship.
Yes.
Sir, Arvind counsel is not available currently, so I'm seeking crossover after lunch. Your lordship will be appearing through VC.
What happened to the amendment? Whether
Sir, it's filed. Sir, amendment has been made. Yes, sir.
then they are supposed to write reply. Madam, reply.
मैंने पहले तो हमारा नाम नहीं है लिस्ट में, तो हम कुछ वो देख नहीं पाते। सेकंड में फाइल है 17 अनेक्शर और हमें कॉपी ऑफ केवल पिटीशन मिला हुआ है, तो हमें एक तो नोटिस चाहिए इस पे। सेकंडली पेज नंबर 2 पे माइलर देखेंगे कि इसमें ग्रीवांस रेस्पोंडेंट नंबर।
ठीक है, अभी you have to hear on admission. We'll see whether it is to be admitted or not.
मैंने इसमें ग्रीवांस रेस्पोंडेंट नंबर 3 से है, हमारा कोई लेना देना नहीं।
आने दीजिए इनसे काउंसिल पे।
जी
नेक्स्ट।
So I wish to withdraw this petition, madam. It has rendered infructuous, Lord the Collector.
Action rendered infructuous, dismissed as withdrawn. Infructuous. Is next. To the mark.
This is against an order blacklisting which is on page 92, Mr. And the clause involved is clause 21, which does not provide for blacklisting. And on 93 is the operative part. अतः प्रधानमंत्री आवास योजना अंतर्गत नवदा परिसर स्थित आवासीय भवन फाइल के विक्रय में आपकी एजेंसी के कार्यरत कर्मचारियों द्वारा अनुचित तरीके से अधिकृत लाभ करते थे संबंध में सुनवाई में आपके द्वारा प्रस्तुत तथ्य तथा विवाद द्वारा आपको जारी कारण बताया सूचना पत्र कि जवाब में प्रस्तुत स्पष्टीकरण संतोषजनक नहीं होने से कंडिका 21 सस्पेंशन और टर्मिनेशन
मार्केटिंग का काम करते हैं लोग। ये
कॉर्पोरेशन के बिहार पे जी। तो बिल्कुल चुनाव के अंतर्गत आपका निष्पादित अनुबंध निरस्त करते हुए जमा परफॉर्मेंस
और टर्मिनेशन विद डिफॉल्ट ऑफ एजेंसी
this clause will not confine on page
21 clause 21
clause 21 below, that is on page 81, page 79 below, I am sorry. I can see page 79, clause 21. Lots of what? Suspension or
termination of this contract.
But there is 20 is suspension or termination without default of agency, so that is not attracted. 21 is suspension or termination with default of agency. The IOMC may notify the agency of the suspension or termination of this contract where the services or any part of them are not provided to the satisfaction of IMC, giving the reasons for such dissatisfaction. And in case of suspension, the action will not
say that only contract can be terminated, blacklisting नहीं कर सकते.
clause नहीं है जी.
ठीक है, issue notice.
So far as blacklisting part is concerned, that may kind
इसकी वो तो final relief हो जाएगी, let them come.
because this may be staged, not because otherwise, because of blacklisting, I will not to participate.
बस सर करो, next week रख लेते हैं.
But such has been stayed by this court also, and as well by Honorable Supreme Court also.
Where order?
Finally, see what I have all such orders. So this is also a non-speaking order because they say कि आपका जवाब संतोषकारक नहीं है. So Kranti Associate judgment will come into play, which is on page 9.
सब बाद में देखेंगे. ये बताइए कि
सर ऐसा ये ब्लैकलिस्टिंग का ऑर्डर भी स्टे हुआ है जिसमें सुप्रीम कोर्ट का पेज 116 134 पे आप देखेंगे 134 पे उन्होंने ये कहा कि क्लॉज नहीं है, इसलिए पेज 134 ऑफ दैट जजमेंट इज रिसीव्ड. Page 134 second heading. Blacklisting was being proposed. This is especially true since the appellant was under the 134 block. The judgment starts for 116. This is UMC Technologies Private Limited. Page 134 has given the appellant the impression that the cause of blacklisting was being proposed. This is especially true since the appellant was under the belief that corporation was not even empowered to take such a decision against him, since the only clause which mentioned blacklisting was not referred to by corporation in the show cause notice. There was a clause within show cause notice which was not referred. Here there is no clause at all below. And then the blacklist at all and not referred in the show cause notice also. Like this. And then there is a division bench judgment of this court which is on page 137. Page 143.
Sir, when does next week will stay? In addition, Amda's requisites by tomorrow. Just next week.
Okay.
Leave to appeal.
But there is delay of 16 days.
All for the records. We'll see thereafter. Conviction. Admit call for the records, 2 weeks time to file reply.
They will write some medical documents also.
मालक
हाँ.
जो पार्टिकुलर्स है मालक वो एक्यूज के साथ ही मैरिज करी है और वो
क्या है ये
Admission
limitation it is none for the appellant filed by 22 days. So delay pending करिए admit call for the records. Next 31
criminal appeal for admission.
delay कितना है? No delay. No delay. Why would you file the application then? Not sealed. It's time bound by 111 days. Therefore, you have filed the application and you said no delay.
Sir, 30.
फाइल देख तो दिया करो एक बार कहाँ है अभी
Application 31.1. That is also for admission. There is no delay.
अरे but we are taking 31 one by one. We don't go to the reverse order. जेल अपील है तो
सब देते हैं कंडोम को.
जेल अपील है ये कर दो ऐसी बिना एप्लीकेशन ये एप्लीकेशन लेना होगा नहीं है ना इसमें डिले है ना 111 days का डिले है
Separately filed.
without application how can we condone the delay?
No, in 31 I use there. 2938.
38
This one. Under section 5 of limitation. I am about 2938/20.
ठीक है तो कर इसको कर दो इसमें हमारा नाम है आईए नंबर 293824 एप्लीकेशन फॉर विलंब का कारण कंडोनेशन ऑफ डिले 111 days delay is controlled ignoring defects फाइल लिए लगा दिया तो डिफेक्ट्स ही नहीं है इसमें लिखा आईए नंबर 252124 एप्लीकेशन फॉर इग्नोरिंग डिफेक्ट्स इज क्लोज्ड admit all of the records.
Or there is a defect that victim is not made a party.
Admission. Admit for the record. Leave to appeal. Leave to appeal for the records. 34. Admission भी है.
Request is, for keeping this matter on Thursday or Friday. I came yesterday late from Jabalpur, Manoj.
What is this?
It's a Corruption Act matter, Manoj. PC Act का है.
There is an application for stay also.
Yeah.
I'm not pressing it.
We'll fix it day after tomorrow or next week whenever it's convenient. The matter would be disposed of finally at the motion hearing stage itself.
Dismiss होना है तो बहुत ही जल्दी dispose हो सकता है. तो allow होना है तो बहुत तक लगेगा.
There are certain grounds, Manoj, which we'll argue it
After 4 weeks,
next week. This will be current
urgency है.
जी हम चालान फाइल हो गया, चार्जेस फ्रेम हो जाएंगे तो द थिंग्स द पर्पस ऑफ फाइलिंग
बहुत मुश्किल है, बहुत टफ लगी हुआ है. कहाँ तक सुनेंगे सभी केसेस, बड़े बड़े मैटर्स हैं सब ये. लेट इट गो आफ्टर 2 weeks. देखिएगा लगभग
रिक्वेस्ट है. अगर आप 11 मार्च वाला वीक फिक्स कर दें तो एटलीस्ट
वीक कमेंसिंग 11th of March. नेक्स्ट
Appeal against the acquittal.
All for the record.
Available in connected one.
Available है.
Yes.
Appeal against acquittal.
Connected में certify हुआ है.
वन में क्या है? सस्पेंशन है. 20 एक्विटल मतलब सम किसी सेक्शन से
There were altogether 4 accused persons who were acquitted under section 313, that is for miscarriage. And the main,
why have you filed appeal against Jagdi?
since the acquittal is under POCSO Act. And conviction is under section 376. POCSO में acquittal हो गया इसमें उसका.
The age must not have been proved.
मान लो. The sole ground
Further petition to next.
The leave to appeal, the notices are not issued yet.
हाँ अभी इसमें सुनेंगे बात नेक्स्ट टाइम.
Madam Sir prepared an application for publication of the summons on respondent number 3. While the summons was set, but no one is residing there, therefore I moved an application for publication of the summons.
नोटिस हो गया था क्या?
Yes, madam.
कहाँ नोटिस हुआ?
Madam, the notices was first served on 9th of August 21.
इश्यू नोटिस तो हो गया था.
Yes, issue notice was, but certainly that was unserved. Why is it was unserved? Therefore, now so August into 25th,
Who is not served?
someone with 3 ballots.
इसमें कोई इंट्री ऑर्डर तो है नहीं. तो क्या हो गया? कॉन्ट्रैक्ट पूरा हो गया?
Yes, madam.
और उसकी उसमें ये हुआ है कि इनके खिलाफ एफआईआर लगाई दर्ज हुई और इनसे वसूली बाकी है रिस्पोंडेंट नंबर 3 से हमारी. अब ये सब कॉन्ट्रैक्टर ये चाहते हैं हमारे से बाकी पेमेंट ले लो. और इसमें एक और चीज है कि सब कॉन्ट्रैक्टर भी उसी का मुख्तियार है नंबर 3 का.
Submit the contracted work to the petitioner.
अभी मेंटेनेबिलिटी
आपने परमिशन दी ना फिर उनको.
बट ये मेंटेनेबिलिटी पर भी है.
In fact, madam, the notices were issued on 6th of August 21 and in September 21 they registered the FIR against the respondent number 3 ballots.
तो लाइबिलिटी किसकी है?
नंबर 3
Madam, there is
Where is the agreement of subcontract? Again, बताइए कि suppose in case respond number 3 defaults, then respond number 1 and 2 is liable to make the payment. ये clause बता दीजिए. आपकी petition maintainable, otherwise कुछ नहीं इसमें. You claim damages or can be by filing a suit.
बट मेरा इसमें और एक चीज है कि जो पिटिशनर है वही रिस्पोंडेंट नंबर 3 का मुख्तार भी है.
कुछ भी है.
Madam, can you see annexure P3 at page number 200? This is a letter of respondent number 1 into.
That is not disputed. They have permitted into a subcontract.
And madam, there is a provision
Now, as per the agreement for subcontract, where is the provision in case of default in payment? The respond number 3 will pay, number 1 and 2 will pay to the sublet contractor.
Madam, that clause is clause 7.5 of the agreement, madam, is number 81. May I take the liberty to read the relevant clause, madam? If the contractor fails to pay any amount due to subcontractor within 45 days and the notice of 15 days received by the employer from the subcontractor, the employer shall have right to decide the same from the contractor's bill, any amount due, and pay the same to the subcontractor as discharge of the employer's contract obligation, madam.
Deduct the same from the contractor's bill or any amount due and pay the same to the subcontractor as discharge of employer's contract obligation.
बट ये पद वाला जनरल डिफॉल्टर नहीं हो. वो डिफॉल्टर है 21 करोड़ की बीजी फर्जी तौर पर बैंक से बनवा कर हमारे यहाँ जमा की. वो डिस्प्यूटेड उसके उससे हमारे को अभी नंबर 3 से ही वसूली बाकी है. तो हम
नंबर 3 को सर्व करो.
That is why, madam, because we will argue on that the reason is not only the 3 appearances required, and if it does not appear, we are ready to argue on the matter, madam.
Application for dispensing with service of notice.
Madam, that is an earlier application, it has rendered infructuous. So recent IA number 6658/23 was filed on 6th of September 23 for publication of submit matters.
Heard on IA 6658/23 application for certificate service. For the regional credit application allowed, बाकी certificate service का order कर दीजिए. Take after publication, you file it.
Yes, ma'am.
Then we proceed.
And I wonder with this now, any newspaper will also be mentioned in the order program.
Private transfer कौन सा local कहाँ का
I
है?
think so Times of India.
Times of India.
Yes, ma'am.
पुणे का है?
Yes, ma'am. That's what I'm saying in Pune, ma'am.
और इसमें लिखिए Times of India पुणे edition.
Yes.
Yes.
Publish.
Well, standard number 3 normally reserved.
And
Normally reserved. Yes.
My lord, in this, my lord, earlier, the Honorable Court directed the respondent to file one circular, my lord. Now I'm seeking only a week's time, my lord. Any fixed date, because my lord, the pleadings in this matter are completed. This is required to be heard finally. So, in the meantime, we'll file that document also, and this will be
The only question involved in this case is whether opportunity of hearing was granted.
Apart from that, circular was filed by them. They have to file an additional reply. They are seeking time from past 4 years to file the additional reply, which has not been filed by them.
In the reply, whether they say that opportunity was granted to you.
yes, my lord.
No, actually,
Reply we have said.
that particular letter is fourth month. That is my contention. And that is why they require to file a detailed additional reply, because the reply that they have filed is not a paragraph reply now also.
Week's time, my lord.
Additional reply नहीं पेश किया आपने.
My lord, we wrote the letter and we also communicated personally with the concerned officer, my lord.
इसके भी तो होगा 8 महीने होगा ना.
My lord. Today, my lord, this matter is listed on mentions.
Mention.
Yes, sir. I take them mention because they are not filing the additional reply.
So, any fixed date, my lord, in 2 weeks, my lord, we will file the additional reply.
Like is for 2 weeks further time by was last indulgence to file the additional reply.
I finally request to continue to file my lords.
Just after 2 weeks, I have to continue.
If I am appearing for the petitioner.
Yes.
But if I want to
Before one of the biggest what is arguments in this, I'm filing a reply today about which I'm not permission. From behalf of respondent number 8 and pointing out the fact not exactly on the same issue for which this petition has been filed. The matter is pending adjudication and a writ appeal at the principal seat now. In form of Lord 7, the writ appeal number 746 of 2006 Lord. And I'll point out, Lord, the proceedings of that in my reply. So I just did not, because we can't be a week's time, not a 3 days time only to file a reply and point that fact.
there has been already a lot of.
So let me finish. Please let me finish. But this petition seeks setting aside of an order passed by Archaeological Survey of India of 7/4/2003 there is an order. Categorically challenging the order, this petition has been filed. Now, Lord, it has been brought to our notice. In all fairness, we need to point out before this honorable court that exactly challenging the same order, a writ petition was filed earlier at the principal seat, which came to be dismissed, against which a writ appeal has been pending since the year 2006. Not that's much earlier in point of time to the present writ petition. Therefore, Lord, you not know that
This is in respect of the same subject.
My senior will not allow me. I am not for the petitioner. My senior will not allow me to face my case.
Last time when this matter was listed, no objection was raised.
No, Lord, that time it was not within a knowledge that same issue, not otherwise it will be multiplicative proceedings with probably dramatically opposite orders from two different seats. Therefore, it's my duty. Will not have any lordship sense.
These petitions have already been admitted.
Yes. Now, sir, as an order sheet, subsequent to admission also, Lord, if I'm able to point out that an analogous hearing deserves to be not accorded to this matter by shifting it to Jabalpur, that can be done. Subsequent to admission also, the issue the Archaeological Survey's order 7.
In previous petition that has been listed before the single bench, that bench has been dismissing the petition of the.
Which has been adopted. May I point out my case, my lords? This matter pertains to Dhar Goshala, my lord.
नहीं तो ये readings complete है इसमें.
Yes, counter has been assigned. I have filed an application.
Time to seek instructions and then address this court.
Yes.
So therefore, this is listed today.
Yes, my lords, I have filed an application.
What is the way out of E and
Yes, lords, I am submitting. Lordship may kindly have section 16 of the Asian Monuments Archaeological Sites Act 1958. For I'll satisfy this honorable. For a moment, Lordship may kindly.
What prayer?
My lords, my prayer today is I have filed an application for ASI survey of this Dhar Goshala.
because the religious character of this premise, according to my submission, respectful submission before this honorable court is of a Hindu temple. And the ASI is in contravention of section 16 of this act, has directed the Muslim parties to offer namaz within the Hindu temple. Lordship may kindly have for a moment section 16 of the ASI Act 1958. And if Lordship may permit me, I'll just read it for the Lordship's convenience. May I read, my Lord? Section 16. I'm so sorry.
प्रतिमा कहाँ है इसकी? What is
it was found in London, brother. They want my senior protection, but they want to, I need to point out in all my senior will not allow me to complete my submissions.
There is a writ of amendment which is being sought to be issued by the Honorable Court to the Archaeological Survey of India to collect a goddess statue from London and get it back to India.
These are the colored photographs. No, sir, just a minute. Let me please my case. Then you will have your turn, sir. Lord, I have 5 colored photographs. Lordship may kindly have for a moment colored photographs which show on the face of it. Lordship may kindly have the colored photographs. Colored photographs. This entire premise is a Saraswati temple. It's a temple of Ma Vag Devi. And all the colored photographs have been filed with the writ. In contravention of the religious character of this property, my lord, the archaeological survey has directed the Lordship may kindly have for a moment.
section 16
Yes, section 16. Yeah. Section 16.
इसमें क्या सिविल सूट भी चल रहा है?
My lord, civil suit was withdrawn. I have given the complete history in the chronology of my case. The point is this, my lord, the controversy is very, very short and it can be resolved by lordships in a very short span of time. The controversy is this, that what is the religious character of this property in question? My submission is, respectful submission before this honorable court is, that the religious character of this property is of a Hindu temple. And if lordship will have the order at annexure P17 by the Archaeological Survey of India, lordship can have page 260 of my petition for a moment. It's a very short controversy.
Why these four cases separately? Same issue.
Some petitions are filed by me. I am appearing in Kuldeep Tiwari, item number 38 and 38.3. And the other 2 petitions are by those who want to open namaz there. Lordship will kindly have for a moment page 260, annexure P17.
In Tiwari's case?
Yes, my lord. In this Hindu Front for Justice case, in item 38.3.
पहले बता दिया को कौन सा फाइल है?
I'm so sorry. I'm so sorry. Look, my senior Mr. Harishankar Jain is also joined through VC. He may also be permitted to participate in the hearing.
So only one person will be allowed to.
Yes. He just joins to that if lordships has any. He will also join the hearing to participate in the hearing.
You are arguing that what is the.
Okay. Good.
You may watch.
Yes, ma'am.
और क्या करेंगे इसके?
Lordship may kindly have for a moment page 260.
Page 260.
260, yes. This is the impugned order in this petition. And precisely this is the crux of the matter.
Then this is a writ appeal order, writ petition order.
No, this is an order passed by the Archaeological Survey of India at page 260. 260. Annexure P17.
Achha, yes.
If lordship may permit, may I read it? I, Gauri Chatterjee, Director General.
Order dated 7/4/2003.
Yes, ma'am. This is the subject matter challenge in this batch of petition. And precisely this is if lordship will decide this issue, it will solve the controversy.
Yes.
I, Gauri Chatterjee, Director General ASI, in exercise of powers conferred on me by Rule 4 of the Ancient Monument and Archaeological Sites and Remains Rules 1959, and in partial modification of order dated 5th February 1998, do hereby direct that the centrally protected monument Goshala Kamal Maula Mosque at Dhar shall remain open in the following basis. That the Muslim community shall be allowed to access to the premises as present for Friday namaz between 1 to 3 p.m. That the Hindu community shall be permitted to access to the premises to hold traditional ceremonies on the occasion of Basant Panchami every year. That the Hindu community shall be permitted to access to the premises free of charge every Tuesday from sunrise to sunset the normal time fixed for opening and closure of protected monument. On the day, the visitor could take flower or two and few granules of rice. That apart from the relaxation enumerated above, the premises shall be open to tourists on all days. An entry fee. So, my submission is that this is a premise of a Hindu temple. And in the premise of a Hindu temple, who will decide? Yes, my lord. The ASI, lordship, therefore, lordship will kindly have my application. I filed an application immediately. And the number of the application is IA number in this writ petition only. Writ petition 10497 in writ petition Hindu Fund for Justice. My lord, I filed the IA.
Appropriate for application for appropriate direction.
Yes, IA number 986. Direction application for issuance of directions to the director ASI. If my lord has this. Yes. My lord, so in this, my lord, I have enumerated the pleadings of my petition in gist for your lordship's kind perusal. And at the end, my lords, I have sought for a direction. Lordship will kindly have my prayer clause for a moment. At page 7. All the pleadings in my writ petition I have quoted in the and what I am asking, my lords, I have mentioned in the prayer clause. Direct the director of ASI to undertake a scientific investigation, survey oblique excavation, GPR survey at the property in question situated in Khasa number so and so within the city of district Dhar, Madhya Pradesh in regard to averments made in paragraph 3 of this application. Conduct a detailed scientific investigation by using GPR survey, excavation, dating method and other modern techniques for the present structure to ascertain the facts stated in this application and also in the writ petition. To conduct scientific investigation in light of the averments made in this application and after the petition, after associating the petitioners and the respondents and their respective counsels and submit a report to this Honorable Court within the stipulated time as provided by the Honorable Court. To investigate the age and nature of the construction of the wall and building in question through scientific methods. To prepare a list of all the artifacts which are found in the building, specifying their contents and carry out scientific investigation and undertake dating exercise to find out the age and nature of such artifacts. So we haven't any objection.
Committee form
Lordship, my respectful submission is, Lordship may kindly have for a moment, Lordship asked me a question that how can this issue be solved? And the answer lies in the interpretation of section 16. Lordship may kindly have the provisions of section 16 for us.
Yes.
Section 16, subclause 1. If Lordship will permit, may I just read it? Protected monument maintained by the central government under this act, which is a place of worship or shrine, shall not be used for any purpose inconsistent with its character. So, my lord, my respectful submission is that it has to be decided that what is the religious character of this premises in question. Without deciding the religious character of the premises in question, the Archaeological Survey of India couldn't have directed the
Straight away directed.
for offering namaz. So religious character has to be asserted.
There has to be some
There has to be an inquiry under the directions of this Honorable Court. And my respectful submission is Lordship may direct the SI to conduct an inquiry within a time-bound manner and submit a report before the Honorable.
Not only ASI. ASI को अकेले को कैसे डायरेक्शन देंगे?
Lordship may direct the also.
Because that remains in the position of the ASI and ASI can hold that.
That's true. ASI के पोजीशन में तभी तो वो ऑर्डर पास कर दिया उन्होंने.
Lordship, sir.
But now the जो कम्युनिटी के हेड है या जो भी है वो सब
They all are in. They all are at that time. I have asked in my application that all the parties must be participating in the SI survey. The community head.
then what would be the final relief?
When the ASI submits a report, suppose my lords, my submission is this. Suppose ASI submits a report and says that this is a mosque premise. Then we don't have to offer the prayers there. And suppose my lord vice versa. ASI submits a report. The religious character of this place is of Hindu temple. It's a Saraswati temple. Then my lords, the namaz cannot be offered there. With greatest of respect. In a premise, my lords, I have shown before this honorable.
How old is this monument?
1,000 year old.
1,000.
Raja Bhoj had made this. This is the place of Ma Devi. This is all the Sanskrit. And my lords, lordship may kindly have for a moment annexure 5, all the colored photographs are filed. All the colored photographs are filed with my writ petition. For a moment. This is
Prayer petition.
one more set I have given. Let me for a moment have the colored photographs which I filed with my petition. I am satisfying this honorable court prima facie that this is a very strong case for your lordships to exercise powers under section 45, read with the section 75 and 2610A of the CPC, and direct the SI to conduct a scientific investigation. Lordship, may for a moment have on the face of it, see the colored photograph which I filed with my petition. This photographs, my lord, start from page 100. The first photograph is of Ma Bharti. In this writ petition only, my lord, 38.3 writ petition. First colored photograph starts from page 100. Ma Bhardevi's my lord's idol is there, which was found from this very premise and kept in London Museum. Lordship, may kindly have the next photograph. These are all the chucks. Shloks of Sanskrit are there, my lord. Still engraved, my lord. And if I may submit, when the people go to offer namaz there are a lot of chances of destroying these important piece of evidence also. These are the shloks, Sanskrit shloks are engraved in the pillars, my lord. These galleries are of galleries of Vedic Hindu temple. Lordship, may kindly photograph at page number 106. How can one offer namaz there, my lord?
CPC में क्या पावर है?
Lordship, order 26 rule 10 है. और वो भी lordship में. Order 26 rule. Commission for Scientific Investigation. Order 26 rule 10. Yes. Where any question arising in a suit involves any scientific investigation which cannot, in the opinion of court, be conveniently conducted before the court.
Now, order 26 rule
10A.
10A.
Yes.
Commission for Scientific Investigation.
Yes, madam. Yes. I'm sorry. Where any question arising in a suit involves a scientific investigation which cannot, in the opinion of the court, be conveniently conducted before the court. The court may, if it thinks necessary or expedient in the interest of justice so to do, issue a commission to such persons as it thinks fit, directing him to inquire into such question and report thereon to the court. The provisions of Rule 10 of the order shall, as far as may be, apply in relation to the commissioner appointed under this rule, as they apply in relation to a commissioner appointed under Rule 9. And Lordship, may kindly have section 75 for a moment. Section 75. Yes. Section 75, I am concerned with E, subclause E. Subject to such conditions and limitations as may be prescribed, the court may issue a commission, that is point number E, to hold a scientific, technical, expert investigation. So therefore, my lord, my respectful submission is to decide the issue and to decide the religious character of this premises in question. It is necessary.
सूट किसने फाइल किया था?
Suit was filed, my lord,
by the respondents.
by the respondents, and it was later on withdrawn. And now today before my lord is the challenge to the order of 7th of April 2003. We are not saying that we need title of this premises. We are not saying. We are not saying that we need ownership of this premises. We are not saying that we need possession of this premises. We need, under the ASI Act section 16, we need right to worship. And Lordship, may kindly appreciate once again the provision of section 16 for a moment. Under section 16, if it's a ASI protected monument, right to worship can be granted. Under section 16, subclause 1 of the Act of 1958, right to worship can be granted. If it is a religious character, is
At that time, no inquiry was conducted.
well, it's in 1902, one inquiry was conducted. But to understand this position as of now, my lords, my submission is, respectful submission before this honorable court is, that it is necessary that
What basis that impugned order was passed?
my lords, impugned order was passed on the basis in violation of section 16 of the Act, without deciding the character of the premises. I'm so grateful, my lord. Should we have
No inquiry.
no inquiry? Without conducting any inquiry, this order has been passed on 7th of April 2003. And my lord, the petitioner before this honorable court is not asking for ownership, is not asking for title, is not asking for possession. They are only asking the right to worship in the premises in question after determining the religious character
Not asking for ownership, title,
or possession.
or position.
Or possession. They are only asking for right to worship.
Only right to worship.
Right to worship. The property will remain with the ASI.
Only right to worship
Yes.
after inquiry.
After inquiry. Let there be an inquiry, my lord. Scientific investigation.
Ownership will remain with
With the ASI.
because it's a old one.
Protected monument. In 1952, it was taken over by the ASI. Before that, also, my lord, in 1901, the ASI was in charge of this premises.
Which
Lord, this is my submission. Lordship, my application may be considered.
But we haven't any objection on the part of the SI to conduct the inquiry.
you don't have any idea.
We haven't.
Yes, sir.
Yes, sir. Yes, sir.
Union of.
So my reply is also.
No, we should.
So my reply is
State
also.
council, no, we should do.
My reply is also on record. In prior 1902 and 93, that inquiry has been conducted. That inquiry has been conducted. Looking towards the page number 29 of my reply, that is an annual report which has been published in the year 1902 and 1903 by the.
Let us come to your reply first.
Yes, state reply. That is a state reply.
Reply to petition.
So, reply of respondent number 7810.
Reply filed by ASI.
ASI.
Union of India.
Union of India.
Union of India.
On behalf of 7810.
Which petition?
Sir, that reply has been filed, reply is on the petition. We have filed a reply. Adoption of reply की application.
मेरा इस्लाम जिसमें है वो पेज आप बता रहे हो.
Sir, same in this petition.
UP 10497.
Yes, sir. That's my adoption of reply की application के साथ reply है.
Adoption of reply.
Yes, this is not my reply. Exactly. That application has been allowed on the last date of the, on the last date of the year.
Which page?
So page number 29 of my reply, comparison page number 29. That annual report has been started, annual report 1902-03 has been started from page.
Archaeological report.
Yes, Lordship. That report has been started from page number 13, that is R1. And on page number 29, the final description has been defined that what is there on the Bhojshala premises. It is discover of the hidden inscriptions on the backs. Got it, Lordship?
हाँ but कहीं कहीं unreadable है पूरा document ये.
नहीं sir, is provided.
Yeah, unreadable.
Please provide it.
Side page number 29. Right? The discovery of the hidden inscription. Back of these slide was that makes a story.
First in two paragraph, it is clearly mentioned about the all the monuments which is found in there.
This inquiry was conducted in
1902 and 03.
So what do you want to say from this paragraph?
Yes, Lordship.
क्या बताना चाह रहे हो आप?
Sir, that all the inquiry has been conducted in the year of 1902 and 1903. So that reports which we want to conduct the inquiry, that is already on record. ये पहले पूरा हो चुका है and that is on record. From this report, it is clearly shown that there is a monuments present in which some pictures is also filed by the petitioner. It's clearly shown that pillar in the pillars, the goddess Vishnu's is there. Some camels, such a camel is also found on the record.
तो फिर ये जो अभी दो 2003 में जो ऑर्डर पास किया है, that is based on this inquiry report.
That is why I think that it took that order has been passed.
ये जो इंक्वायरी कंडक्ट हुई है इसकी रिपोर्ट को they are not considered while passing the improved order.
Yes, Lord.
So very respectful.
This inquiry report not considered. So he says, where is the necessity to conduct another inquiry when this report is there?
My submission is that this report was of 1902. To understand the spot position as of now, it will be in the interest of justice, Lordship may direct the SI to conduct an inquiry. As of now, because after 2003, because this report, when this report was filed, after that, the 7th April 2003 order has been passed. So 7th April 2003 order has not decided the religious character. So there has to be a decision.
Order which does not decide the religious character.
3/1988.
My submission is that under section 16 of the Act, this after passing of this
पुरानी रिपोर्ट में इसमें सब दिया हुआ है कि क्या क्या मिला ये गुजरात ये सब इस रिपोर्ट आंसर और क्या बोल रहे हैं आप?
I'm appearing not for respondent number 8 in these matters.
Respondent number 8.
Yes, please.
एक मिनट.
Yes.
In this very particular
petition, and WP number is 10484 also.
WP 10497.
Yes. Yes, please.
And WP
10484 of 22.
Who is respondent number 8?
It's society.
तो मेन बेंच का ऑर्डर देना जरा. Where is that?
But it's pending adjudication and notice also from the Lord.
The writ has been dismissed.
No, the writ appeal is pending. The
Writ appeal is pending.
writ appeal is pending. The writ petition was dismissed earlier again.
Writ petition का ऑर्डर दे दीजिए और appeal का नंबर दे दीजिए. So
They have just point out.
that will find out whether it is similar, identical matter, and
I just want to point out to you, Lord.
whether there is any stay in the
No, there is neither a stay here nor a stay there.
So that order is
Point out, may I just point out two small things?
on P18, that order is there.
Would you not permit me to take your lordship through the relief clause in 10484? 10484, the relief clause.
10497 है ये.
Not 10484. I forgot to correction.
तो हाईकोर्ट का ऑर्डर P18 है. एक सेकंड,
Number 261.
P18. Page number
Page number 261.
61.
And WP number 10497.
4216 not. It is WP number
4216.
Yeah, 4216.
That order has been part of the single bench lordship. Readable number 748 of 06.
784.
That readable justice.
ये तो इशू दूसरा था इसका.
Next,
This is not the issue.
मैं point out exactly वो issue. Just for a minute, if your lordship permits me.
हाँ.
May I take your lordship through the relief clause note of 10484?
Sure.
10484.
Yes, sir.
Yes, ma'am. Your lordship, I kindly turn to not the relief that is being prayed for in para 11. Your lordship has it? Para 11 of the petition. Your lordship has it? The first relief order is order or direction in the nature of mandamus directing the government of India and ASI to photograph all inscriptions, artifacts, images available in Dushala complex and to preserve and protect them. Now, not come the relevant reply. Privy. Issue an appropriate rate order or direction in the nature of mandamus directing the respondents to ensure the Pratima of Goddess Pardevi is restored, re-established within Bhutshala complex after bringing the same from British Museum at London, and to ensure the member of Hindu community are allowed to perform puja and rituals of goddess. For two reasons, number one, in my respect of submission, no such mandamus can be issued by this honorable court directing the ASI to procure a statue which is outside India and to get it back. In any case, not this relief.
This relief cannot be granted.
Not, we have not, that's just not, it doesn't end here, but now your lordship may turn to a Roman free relief. Issue an appropriate rate order in the nature of mandamus, restrain the government of India, ASI, and all other officers working under same from allowing Muslims to offer namaz within Bhutshala. Now what comes forth, out of which the rest of the reliefs flow. Para 4. Issue an appropriate rate order or direction quashing para 1 of the order dated 7/4/23. Passed by DG, ASI, and also to quash the conditions imposed in the order restricting the right to work. If if 4 is granted, only then 2 and 3 can be granted. Because unless that order of the ASI stands,
And is allowed to say, he's not asking for this relief at this stage.
Yes. As of now,
He's not asking.
Yeah, relief with my learned friend is asking in 10497.
10484.
One deployed by relief that has been sought in months, because this is the release in 1048. So
Now, this thing, in any case, we can't grant this relief. At the most, if at all, there can be a direction to
ASI to conduct an inquiry.
Indore will pass an order.
With great respect, may I submit one thing?
Or show us
Yes.
that inquiry was conducted and ASI has considered all those findings of the inquiry report.
Yes.
Then petitions have, will go. They can survive them.
Yes, I'll show you for sure.
Otherwise, there would be violation of section 16
Yes.
of the Archaeological Survey of India Act.
Precisely. I just point out one thing. Unless this order of 7/4/2003, Lord, with great respect, I would submit it set aside by this honorable court in its entirety.
Which order?
This 7/4/2003, Lord, because the relief that is flowing
At present, we will not touch that order unless and until there is an inquiry.
now,
How can we touch it?
with that order standing,
Otherwise, there will be law and order problem.
with the order standing the way, if the order is standing the way it is standing, not with great respect, the relief that is being asked for, even as an interim relief or final relief in 10497 cannot be granted for the simple reason that there is an order passed by the ASI. The ASI's order says that this is what needs to be done on the site in question. Your Lordship may permit me once again to take your Lordship through that order.
Show us from any document that before passing that order, this inquiry report of 1902-3 was considered. Because there are several findings in that report which you read at.
Not with great respect, assuming that that order, whatever,
When we brush it aside like that.
but your Lordship Lord would be pleased not to brush it aside. The order of 7/4/2003 also for the minute, unless it stands, unless it is completely set aside, not to say it is all right for the ASI now to do a volte-face before this honorable court, take a different turn for what they did in the year 2000. In fact, the order ought to have been defended by my learned friend here.
And we submitted the fact before the court.
Please let me submit. Now that order apparently is not being defended for obvious reasons by my learned friend appearing for the ASI. If the ASI is unable to defend its order 7/4/2003 Lord and state that this order is illegally and arbitrarily passed by the organization which he represents in the year 2003 Lord, then it's a different thing, then that order may be set aside. Every order going from the order also deserves to be set aside. But unless the order stands,
That we are supposed to see whether that order is
yes,
in consonance with the Archaeological Survey of India.
may I point out what exactly has been said in that order?
How will you say कि ये गलत है? ये उनको defend कर रहे हैं. Submitting the fact. Submitting the fact before the.
May I take your Lordship through the order Lord of 7/4/2003? The order that we have read. Let me for my own benefit take your Lordship through the order. What does it say? In face of that order, is it appropriate on part of the petitioner in these two petitions to ask for a relief which is contradictory to the order of 7/4/2003? There is an order, right or wrong, which stands today. Unless that order is set aside, with great respect, I submit one, not even an interim relief which is asking to conduct a resurvey.
See subsequently after the report is placed before this court.
That's what I'm.
Because we cannot set aside merely on the submissions of the learned counsel.
Yes. Take your Lordship only through not. But one is the order of 7/4/2003. Now, about four things have been mentioned in the order. One, that the municipal committee.
Where does it mention that they have taken into consideration this act?
Not that
Section 16. They are mentioning that powers conferred on me by Rule 4 of the
government departments.
partial modification of this.
Government departments are not required to mention the sections under which these orders are passed. It's with great respect. A lot of times we come across government orders which say that these orders are coming back without mentioning the section and saying that we derive power from such provisions.
What basis they have arrived at this conclusion?
Therefore, not this order deserves to be set aside. If I'm not correct in bothering your Lordship,
Still we will not take that unless we have something on that.
something. I'm completely bound down to your Lordship's observation. Therefore, this order stands. Now, with the order standing in present part,
At present, the system going on will continue.
Yes. And may I not point out, now may I point out and pass on to your Lordship not the rate appeal relief which I have sought, which has been sought in the court, and what I am submitting earlier is exactly the same reliefs of 7.
Are we stopped from deciding these cases when the writ petition is pending before the court?
And I've seen analogous here.
If you see the prayer clause of the writ petition,
Yes, Lord.
that is something different. relief which is came indirectly and circumventing the order of the archaeological survey. The same relief. Through the relief clause.
That is identical to these petitions.
Very much exactly the same words, expressly, impliedly.
Cases pending in Jabalpur are identical.
WS 784 of 2006. Vishnu, let me finish.
Cases pending in Jabalpur are identical.
Yes, but WA 784 of 2006.
WA
784 of 2006.
784 of 2006.
Yes,
and that is pending.
yes, that is pending at due place.
उसकी कॉपी लगाइए, इसमें नहीं है, लाइए दिखाइए. चैलेंज करो. नहीं. अच्छा, 2003. रीजनल पिटीशन दिखाई दी अभी आपने, कहा है पेज नंबर
261.
261. ऑर्डर है, ऑर्डर है, इट इज एन ऑर्डर.
Single judge.
So where is the prayer clause?
Yes, sir. No.
पिटीशन की कॉपी है क्या?
Petition copy not be.
नहीं, आपके पास दिया भाई.
इसलिए आपसे वो निवेदन कर रहा था कि नहीं, वो पिटीशन की वो कॉपी तो मेरे पास भी नहीं है. The only thing is, this is exactly the same relief which was sought for, because the reliefs can't obviously change in a writ appeal from a writ petition. We'll have to stick to the same relief in the writ appeal also, which we had asked for in the writ petition. So must be the same relief, except for the.
So we want to confirm what was the relief clause in the writ petition and before the principal seat. ऑर्डर में नहीं है ना, रिप्रोड्यूस नहीं है. It only says quotient of P1, P2. What is that P1, P2? We don't know.
And my lord, I am also submitting.
But yes, yes, a copy of this writ petition. So let us see.
Editorial judication is also before this one.
Yeah, canteen of the. बाजी मारने में आप ऐसा वाला था. इसका
That petition is asking for.
Who had filed that writ petition?
Respondent number 8. No, he was not a petitioner. Some different 5 persons.
Because some he was granted to file a civil suit.
Yes.
Civil suit was filed, that was withdrawn.
Dismissed in legal.
They were not a party in this
We
petition.
were not part.
Survey was a party.
Yeah, archaeological will be there. There is no doubt.
It's like
These petitioners are not party to this case.
It's like this. What happened with archaeological survey plot order of 2003.
एक मिनट, ये इसका देखो, इसका मेन पेज भी नहीं है. प्रॉब्लम वो और सिविल सूट किसने फाइल किया? सिविल सूट का पेज नंबर
Civil suits were filed by one Amiruddin. In my list of dates at page 7 I mentioned.
As the counsel for the petitioner submitted five power of action wherein the proper quality. That is, even the question of territorial jurisdiction has been left open, has not been decided.
Yes.
They said that five cause of action arose in Bhopal. So court said that disputed questions of facts are involved, therefore we refrain to entertain these writ petitions. And that issue was never decided.
Never decided. My submission is that the territorial jurisdiction of this premises in question is within this honorable court.
Naturally.
Natural. Therefore, my lord, we have filed a writ petition.
Are within the jurisdiction of Indore bench.
And writ appeal was dismissed, then later on SHRI was withdrawn. I mentioned.
Where?
Yes, lordship may kindly have. For lordship may have for
Writ appeal against this order?
Yes, my lord.
Single bench order?
No, my lord, I am mentioning. I went in SLP. Lordship may for a moment have my chain of events in my list of dates. For a moment. If lordship may have this for a moment from page 7 onwards. I have mentioned chronologically the entire event. All the disputed things have the lords pointed out. Lordship, kindly from page 7. The central government handed over Goshala to the ASI. In 1961, my lord, there is an event of Dr. Vishnu Sridhar. You may skip it for a moment. Then Lordship may have 1962 event. Civil suit number 40 capital A was filed by one Amrit Blue, claiming exclusive right of worship of Muslims in Goshala. Then my lords, on 4th of May 1964, we filed a Hindu parties filed written statement in the civil suit. ASI filed a written statement in the said civil suit. And this civil suit, on 27th of September 1969, the plaintiff did not appear, so it was dismissed in default. I'm giving the history, the checkered history of all the petitions which have been filed in this. Then, my lord, on 12th of March 1997, the then Chief Minister had passed this order banning our entry. Then, my lord, one Vimal Kumar had filed a writ petition 1295. This was withdrawn, my lord, later. On 28th of January 1990, I mentioned, but me kindly page 8 of my chronological events.
So बहुत कुछ हो चुका है मतलब.
So, but as of now, my submission is that this batch of 4 petitions are fresh petition before this honorable court, and there is no stay, there is no judicial pronouncement so far as this issue is concerned. With a lot of sense of responsibility, I am making a submission before this honorable court that there is no judicial pronouncement so far as this issue is concerned. And this honorable court has territorial jurisdiction to decide this issue, and therefore, my lord, this petition has been filed before this honorable court. Everything, there is no suppression. All the things which have happened, I have mentioned in my chronological list of events. The LPA was dismissed, which lordship was seeing the page 261 order. That LPA was dismissed.
Page 261 is
The single judge order.
single judge order.
The LPA was dismissed on 5 September 2005.
Where is that?
Well, as I mentioned at page 9.
They say that writ appeal is pending.
No, sir, writ appeal is not pending.
Writ appeal is pending, Lord, which I have just shown you.
Against this order WP 4216.
Yes. That's been mentioned, Lord, in the writ appeal which I just passed on to your Lordship.
Then how this second writ appeal is maintainable? LPA
Supreme Court against the.
Let us see the LPA order first. You have to be very clear, right? We have to mention everything. Yes, the order. Yes. So where is this LPA order?
Yes.
Because it doesn't find place in your list of dates.
Yes. In my documents, it's not there, but in my list of dates, it's there, my lord. Page 9. 5/9/2005.
We want to see all these documents, otherwise how can we empathy consider?
For a moment, have page 9.
Page 9.
On 5th of September 2005, the LPA, Qazi Zakaullah, was dismissed by the Honorable Court sitting at General.
This petition was filed by Qazi Zakaullah. So at that time in 2003, LPA was dismissed. नहीं, LPA का प्रोविजन था।
Yes, sir.
रिट अपील तो 2005 में आई।
5 के बदल।
एक्ट इटसेल्फ इज 2005।
2006 की।
हाँ।
5 September 2005. Lordship may kindly appreciate 5 September 2005 I mentioned in my
अच्छा, against that they went to the Supreme Court also.
They withdrew their SLP.
तो क्या कौन सी रिट अपील पेंडिंग है आपकी?
That's what.
हो सकता है कोई दूसरे ऑर्डर के खिलाफ रिट अपील पेंडिंग हो।
सब उसी में लिखा रेट अपील में किसके खिलाफ पेंडिंग?
That will be dismissed in any case. That will be dismissed.
What happens?
If these things are pointed out,
Territorial jurisdiction is an issue there. Territorial.
territorial jurisdiction not touched.
Not
that will have no single judge.
And my lord, we were not parties there. In any case, we were parties. This is a comprehensive batch of petitions which is before this honorable. And what the petitioners are asking before this.
Now let us clarify रिट अपील किस चीज की है, ये बताइए।
May I not have the copy of the writ appeal packet? The prayer clause of the writ appeal is self-explanatory. It mentions as to against which order is the writ appeal filed. The prayer clause of the writ appeal. What happens to the writ appeal court? Presently, I will
Rising out of 4 to.
I'll explain.
That means this is absolutely misplaced. Suppression of facts ना है भाई. When the SLP has also been dismissed.
Yes.
How another writ appeal can be filed against the same order? Why are you keep it pending? वहाँ जाके लगाओ कुछ करो उसको।
वो ASI उसमें पार्टी है। ASI अगर अब तब तक डिफेंड करके बात बता देता तो फाइल हो चुकी होती। It's like this one. I'll just go back a minute. If my learned friends on both sides permit me for a minute, not in all fairness. So what has happened is brought.
Suppose this fact is correct. LPA dismissed, SLP dismissed, then this second writ appeal is not maintainable. In any case,
It's like this. Not the present respondent number 8 not of this before this court.
9. The Honorable Supreme Court have permitted Qazi Zakaullah to withdraw SLP, providing that he was liberty to take steps for revival of his LPA. So I think that after this order of the Supreme Court, the writ appeal, which was earlier dismissed, would have been revived. I don't know what my senior has placed before this order.
fresh writ appeal could not have been filed in the light of liberty granted by Supreme Court. LPA is 2003. In that, they have to file an application for revival in the light of liberty granted by Supreme Court.
Yes, sir.
They have filed a fresh LPA. Fresh WPA. जी.
And what has happened? The petition was filed. About against the order passed by the archaeological survey. That petition was dismissed. Again, my LP was preferred. That's why dismissal is not maintainable. Again, that SLP was filed. And during that time, the writ appeal came into force. So the Supreme Court permitted them to withdraw that SLP, permitted to file WP. So the WS.
Liberty to take steps for revival of letters patent appeal before the High Court. Revival, word has been used.
But the Supreme Court has permitted them not to file WP.
What is not revival? What is that process? Sir, revival.
Revival.
Revival. We want all the order sheets. Without that, we cannot give a finding like that. We have to mention everything, we have to reproduce everything in the order. This order has been passed by the Supreme Court, this order has been passed by the High Court.
I mentioned it, the SLP number and the
SLP, but where is the order? You will have to provide it.
My senior was having the objection, so I thought my senior will provide.
We have not now concluded with it. Permission from both my sides.
After all these things, that the pendency of a writ appeal before another bench is not a bar.
Yes, suppose Supreme Court has given liberty to file a writ appeal.
Writ appeal.
Then certainly this is maintainable.
Yes,
and if there is a liberty to revive the LPA, then this is not maintainable.
We file that order. But my submission was that despite the pendency of that appeal before the division bench of of this High Court, my submission is that the territorial jurisdiction to decide this issue is with my lordship. Is with this order.
Territorial पे किसी को objection है ही नहीं.
And there is no.
We are on a different issue.
No, if you see the order, there is. If you see the operative motion,
This government that I represent, ASI.
Para 46 पढ़ रहा है. Referring to enter into the question, other questions agitated at bar that this writ petition should have been filed. Indore bench, as the counsel for the petitioner has submitted that part call of action has arisen at Bhopal. Bhopal कहाँ आ गया? Actually Indore होना चाहिए. उसमें देखा कि in my opinion that petition itself is not a proper remedy. इसमें ना ये not necessary to go into any other questions as and I refrain myself from entering into the disputed questions of facts in this writ petition.
In that,
Therefore dismissed.
in that petition, neither my learned friend who being represented, nor was I there a party. It was the archaeological survey then which was being represented. I was respondent number 8. It was not a party in Jabalpur in the first writ petition. He is not a party in the writ appeal also not. Neither the persons my learned friend is representing as petitioner, they're a party. So we can't actually comment on what happened in Jabalpur, except for just bringing to your lordship's perusal and cognizance what has happened in Jabalpur.
We want order sheets, that's all.
Yes. So may I not conclude in 5 minutes?
Whatever might have happened, order sheets will spell out.
Yes. Now may I not conclude my arguments just by pointing out the relief which my learned friend has paid for in 10497. And why this relief with greatest respect, not even an interim relief flowing out of these final relief, there is to be granted by this honorable court at this juncture by going through their original relief not paid for in 10497. What should we grant to the relief? First relief. What has the relief of? Yes. 10497. Now I'll just go through the last 3 lines. Old Vatshala situated at Kasara, Roman 1. Skipping the earlier 4 lines, Kasara land number within the city, within the city of Dhar, state of Madhya Pradesh, and the members of Muslim community have no right to use any portion of the aforesaid property for any religious purpose. This relief is a final relief which flows from setting aside the order of 7/4/2003. Unless the relief not paid for in 7/4, the order passed in 7/4/2003 can be set aside. This relief obviously cannot be granted because they are actually seeking the quiescent of the any diversion from the order of Archaeological Survey of India in 2003. Any diversion,
diverting from the order,
submits me not 5 minutes of not asking a stay of this will continue till 4:30 to go conclusion which you don't let me finish. But Roman 2 not now.
Unless this 2003 order is set aside.
Yes.
No, relief number 1 cannot be granted.
Yes, it's not. I'll treat the entire relief. Treat the entire relief from 1 to 8. Prayed for. All reliefs which have been claimed, in fact, indirectly or directly pray for setting aside of the order dated 7/4/2003 passed by the Archaeological Survey of India. You actually refers to any order. Now, rightly or wrongly, that order stands. Wantingly or unwantingly, wittingly or unwittingly, that has been challenged in a rate appeal pending before the principal seat. I am not requesting Lordship not to refrain from passing an order one way or the other. We can always have a hearing on merits on order of 7/4/2003. We can have a prior judgment. I'd love to have that. For a change, Indore bench will have a preceding roll call over the principal seat of Jabalpur. No, there is no. But the fact of the matter, Lord, is that unless that order is set aside of 7/4/2003, no, interim relief also, whether it is in the form of a relief or in form of an application praying for a survey to be conducted on the site can be granted. Because what the question that I put to myself is, why should a survey be conducted at all? If there is an order by the ASI which says that this is what is going to happen on the site in question.
We have to see whether that order is in conformance with the provisions.
Which will
Section 16.
Just told me. I'm sorry.
Section 16.
Section 16 not, I'll take your lordship to section 16 also. Section 16 not, the role of section 16 is to give a decisive character to the site in question, which has been done by the ASI. The order of 2003 of the ASI, in fact, gives the decisive role.
समझ क्या था It's just like Ayodhya, if I'm not wrong. Same issue.
Different not. As far as because YouTube is on, I refrain myself. As far as Ayodhya is concerned, the whole nation is with the construction of the Ram temple, regardless of the caste and the creed. And we are all happy. All Indians are happy, regardless of the caste and the creed. But here is not a dispute about anything. Here is a dispute about whether a given place, unless it is rightly or wrongly declared by the
My lord, I have the order of the SLP. Exact I have used the same words which were used by the Honorable Supreme Court in past. I gave a printout.
प्रिंट सब दे दीजिए
Yes, sir.
वो एक डॉक्यूमेंट है उसका प्रिंट आउट है
You can scroll down the iPad.
Rising out of WP 4216 2003 and LPA number 766 2003.
Yes, same.
क्या ऑर्डर क्या है?
In the, you may scroll down the iPad.
अच्छा permitted to withdraw the special leave petition with liberty to take steps for revival of his letters patent appeal before the High Court.
बस बताइए.
रिट अपील फाइल करने का बोला नहीं है जो पुरानी पेंडिंग रिट अपील्स थी those writ appeals have been have been converted into writ appeals. Not they have been not re-registered as writ appeals. इसका मीनिंग ये है Not there was no permission from the Supreme Court to file.
ये एक अर्जी उस रेट अपील में लगा देते हैं 2006 से पहले
Information. सरकारी काम से देंगे
छह से हो चुकी होती है डिस्प्यूट नहीं लगना
स्टैंडिंग काउंसिल साहब मैं क्यों कर डिसमिस करा करा सकते ऐसे लगेगा इनको इसको आइडिया दिया था
सर मैं तो खुद के लिए वर्स्ट केस सिनेरियो इमेजिन कर रहा हूं मान लीजिए पेंडिंग भी है छोटा पावर है जो टॉक्सिक टेकिंग a decision
council why don't you file application
Sir, just now I'm getting it.
You are getting salary. You get remuneration only after you decide the cases. Get the cases decided.
Filed that application before.
इनकी मदद हमने
हम लोग को we are not here to give you advice.
मतलब मैं मतलब against the WB 2844 of 2019 my lord. That is Maulana Kamal petition my lord. In para number 6 of the petition my lord. They themselves stated that they have also filed a petition before the public bench and that was dismissed on the ground of territorial jurisdiction my lord. And then they petition was filed in 2019.
मैं दूंगा ये जितना बोलेंगे उतना जवाब देने में मजबूर हो जाऊंगा
आप भी सब बना के दे दो लाइन से पिटीशन छोड़ो आप तो बताओ सीक्वेंस क्या है इसने क्या फाइल किया उसके ऑर्डर दो हमको Writ appeal is also pending.
Pending as a different order. About performance of either puja or namaksha. That is the only point in that.
That point is different from the order.
That point is different.
ये तो अभी एक काम करिए आप जबलपुर में क्या क्या पेंडिंग है क्या क्या हुआ पहले से वो थोड़ा सा सिनॉप्सिस बना दीजिए विदाउट दैट विल नॉट पास एनी ऑर्डर यू हैव टू मेंशन एवरीथिंग उसका प्रेयर क्लॉज सब कुछ लिख के फिर देन विल कम टू ए कंक्लूजन ठीक है
We will make it in form of a written submission. We'll file.
हाँ जस्ट एकदम बहुत ज्यादा लिखने की जरूरत नहीं है ऑर्डर होना चाहिए
Date of events and order copy.
ऑर्डर भी होना चाहिए
Yes, yes. And my lord, I will also submit that I have checked the orders in the writ appeal appellants. The petitioner in the writ appeal is not appearing. It's mentioned in the orders. I've got the 6 orders.
अपने जल्दी देना इसको
Yes, sir.
give it as early as possible
Identically.
Reserving order.
उधर की उधर नहीं करना है नहीं we are not disposing of the entire petitions we are only hearing on your IA
So
that's all so we have to decide that IA
yes.
Why I have application?
I will give the orders of writ appeal and the assent.
इसमें कोई भी ये रखे इसको
One where I tried to.
यही है शायद
Doctor, we are fixing on some specific.
I will pass the order. इसमें अगर कुछ करेंगे तो डायरेक्शन देना पड़ेगा.
Yes, yes.
Either we'll reject your application or allow. इससे ज्यादा कुछ नहीं होगा.
Yes, yes.
And then it will be processed for final hearing.
Yes, I'm not grateful to you, Lord.
I will give a declaration. But my eye is also waiting for the same relief. It is not argue that. Let me also be directed to the
आपका आईए नंबर क्या है?
8933.
In which case?
Same in the front. 23. 28.3.
38.3.
38.3 में है आपकी आईए.
Identical आई.
Same IE. Same player.
933 23 आईए.
And therefore respond number 9 now.
Respond number 9. Yes, next.
I'm so grateful. 39.
Yes, claim for the applicant for the Lordship compensate appointment was rejected. On the last date of the notice was issued.
Notice issued. Notice for work.
Lordship, the single judge Lordship has rejected the writ petition on a ground Lordship which was never assailed in the written order as well as in the writ petition and in the reply also. The Lordship, the appointment was Lordship rejected on the basis of class 4 subclass 2 of the policy Lordship dated 15/11/2017. This is Lordship election P11 page number 51 of the writ petition. आश्रित परिवार के किसी भी सदस्य के शासकीय अथवा अर्ध शासकीय संस्था में नियमित सेवा में अथवा 5 वर्ष या अधिक अवधि से संविदा सेवा में कार्यरत होने की दशा. So, Lordship, one of the other of the applicant who is in government service, Patwari, but he is residing separately just before the death of the Lordship father.
This cannot be a ground. The son, the brother who is employed is not taking care of the family members, including the old aged mother.
My lord, for that, because my lord, how this can be drawn that he is not.
अरे आप थोड़ा सा जजमेंट देखा करो ना.
My lord, I saw the judgment which
ठीक है, जहाँ है वही है.
नहीं my lord, मेरा
इसमें इंक्वायरी करना पड़ेगा आपको. अगर एक भाई को नौकरी मिली हुई है और इनको पालता ही नहीं, इनको पैसे नहीं देता, तो फिर व्हाट इज द यूज? किया सुप्रीम कोर्ट ने
पिटिशन में
अपना प्रिंसिपल शीट का भी
वो जजमेंट है ना.
हाँ, उन्होंने
अनुसार इनटू दैट.
my lord, रिट पिटिशन 2 ग्राउंड्स पे डिस्कस हुई है my lord. पहला ग्राउंड तो जो ये रेस कर रहा है वो वाला, सेकंड ग्राउंड अगर कंसीडर करें तो उसमें ये भी था कि ही वाज आल्सो इन द गवर्नमेंट जॉब my lord earlier petitioner.
आई वाज जस्ट ग्राम पंचायत में Lordship रोजगार सहायक में.
और उसके बाद इन्होंने 10-11 साल का ये पिटिशन.
नहीं, रोजगार सहायक तो रेगुलर बेसिस पे सिलेक्शन होता है उसका. ही इज एन एम्प्लॉय ऑफ द पंचायत डिपार्टमेंट.
अंशकालिक में हुआ तो मैंने वो डॉक्यूमेंट फाइल की है, लेकिन रिजाइन करने के बाद Lordship मैंने
नहीं, फिर ये तो बिल्कुल सही ऑर्डर है कोर्ट का.
नहीं रिजाइन करने के
अरे आप 11 साल एक जगह नौकरी कर रहे हैं, उसको छोड़ के आना चाहते हैं, तो दैट इज नॉट परमिसिबल.
बट Lordship टाइप ये तो हो कि कोर्ट 2 का जो Lordship प्रोविजन था,
ये हमने नोटिस इसलिए कर दिया कि भाई आपने कहा था कि हमारे ब्रदर इस ग्राउंड पे रिजेक्ट किया कि हमारे ब्रदर नौकरी में है एंड ही इज नॉट सपोर्टिंग द फैमिली. दैट इज व्हाई वी सेड कि यस इट हैज टू बी इशूड. But suppose if you are in service and rendered 11 years of service, then
they only Lordship 2 years, 2 or 3 years.
Single year का ठीक है.
11 years seven father की तो डेथ से Lordship
the petitioner has already secured the job of Gram, but he resigned and now claiming compassionate appointment.
Yes, Lordship.
But not 11 years.
वो जो 11 ईयर्स का जो टाइम बताया ना कि वो अगर कि डेट से राशि विकास होता है कि 2010 में डेथ हो गई थी राशि पॉलिसी के लिए 2017 में राशि तो वो जो 11 ईयर्स काउंट किया ना राशि वो डे था फादर से पॉलिसी तो 2017 में जब तक तुम्हें क्लेम कर नहीं सकता था राशि 2017 में जब पॉलिसी आई है तो वो असली आपके लिए अगर आपके फादर 1-2 साल पहले मरे होते तो फिर बात अलग थी बट जो कभी 10-20 साल पहले मर गए तो वो पॉलिसी अगर अभी आएगी आज से 15 साल बाद तो क्या वो लागू हो जाएगी? Rashid, there is a that cannot be applied retrospectively. Really, but Rashid, can you see annexure A2 रीट अपील का राशि उसमें लिखा है कि आदेश 1 अप्रैल 2008 से प्रभावित होगा रिट्रोस्पेक्टिव ही इसका राशि इफेक्ट डेथ का वही फादर 2012 में हाँ तो ये बाद में आया राशि इसमें ये डेटेड 16 फरवरी 2018 को जो मैंने फाइल किया है कहाँ पे है पेज नंबर 15 पर शुक्रिया आदेश 1 अप्रैल 2008 से प्रभावित क्योंकि यहाँ पानी से आई तो रिट्रोस्पेक्टिव कहाँ जो अर्लियर ऑर्डर था लास्ट पूरी पॉलिसी की कॉपी कहाँ फुल पॉलिसी ये मैंने लगाई ना P11 पे 51 रिपीटिशन नहीं तो 2008 से लागू की उसको यस ये हाँ नहीं पिताजी मरे 2012 में यस अप्लाई कब किया आपने मैंने राशि इस पॉलिसी आने के बाद किया 2019 मैंने एक बार 2018 में किया तो आई वाज इन द सर्विस कि मैंने वहां से रिजाइन करने के बाद पॉलिसी 2018 में आई 2017 में आई थी 2017 में आने के बाद ये राशि 2000 नवंबर 2017 मतलब अर्ली 2018 बोले राशि तो हमको नॉलेज राशि 2018 में हमने राशि तुरंत फाइल कर दिया जैसे मेरे नॉलेज में आई राशि अरे अनएम्प्लॉयड होना चाहिए ये नौकरी कर रहा था ये एट दैट टाइम बाकी मैंने फिर 2019 में फ्रेश एप्लीकेशन फाइल की लक्षित और आप अगर ये की कब रिजाइन किया आपने ग्राम रोजगार सहायक से कब रिजाइन किया ये लक्षित आई रिजाइन ऑन 1/11/2019 हाँ तो एक 2020 बिल्कुल नहीं मिलेगा और आप एक डॉक्यूमेंट नोट देखें लक्षित प्लीज ग्राम रोजगार सहायक से अच्छी नौकरी थी वो ये सचिव था लक्षित ग्राम पंचायत फादर वाज सेक्रेटरी इन द ग्राम पंचायत वो लक्ष्य आप ये भी देखिए मैंने जो डॉक्यूमेंट पॉलिसी देखो पॉलिसी अगर ऐसी इधर उधर बहस ना करके पॉलिसी देखो किसको इज द पर्सन एलिजिबल ठीक है ना वो पेज नंबर 51 ऑफ द रिट पिटीशन हाँ तो आज पूरा आप देखूंगा ये पॉलिसी है क्या बस इतनी है ये बस 2 पेज निम्न परिस्थितियों में मृतक के आश्रित परिवार के किसी भी सदस्य को अनुकंपा नियुक्ति की पात्रता नहीं होगी इसमें जो सब पैरा 2 है आश्रित परिवार के किसी भी सदस्य के शासकीय अथवा अर्ध शासकीय नहीं ये पेज नंबर 51 पढ़ रहा है ना यस सर आवेदक मृतक पर आश्रित सदस्य होना चाहिए हाँ आश्रित पर ये आश्रित था क्या एट द टाइम ऑफ डेथ ये लक्षित जॉब एट दैट टाइम तो हाँ तो इज नॉट आश्रित आश्रित का मतलब एम्प्लॉयड डिपेंडेंट डिपेंडेंट ऑन द फादर अब ये तो ऑलरेडी नौकरी कर रहे थे
कोई भी एक भी सदस्य गवर्नमेंट जॉब में होना चाहिए यहाँ तो दोनों गवर्नमेंट जॉब
नहीं वो अलग बात है फिर ये दूसरी हेलो
लेकिन 7 साल तक उन्होंने गवर्नमेंट जॉब करी फिर छोड़ा और फिर उसका
बिल्कुल सही ऑर्डर है ये जो ग्राम रोजगार में इसलिए जब जारी किया था लाठी वो आश्रित के कैटेगरी में आता है कि जो आदमी नौकरी कर रहा है कैन ही बी टर्म्ड एज एन आश्रित एट द टाइम ऑफ डेथ ऑफ द फादर लाठी हां ही वाज इन जॉब हां ही वाज इन जॉब 2017 में ही वाज नॉट डिपेंडेंट ऑन द फादर बाद में रिजाइन करके फिर से वापस से अप्लाई तो ये तो काल्पनिक बनाई गई है आश्रित था तो अगर आप नौकरी कर रहे तो रीजन थी उसमें क्लियर लिखा हुआ है कि अनएम्प्लॉयड जो डिपेंडेंट है उसको नौकरी ऐसा थोड़ी हाँ वो करता है आजकल वो पिताजी को ही मरवा देते हैं
क्योंकि हमको नौकरी मिल जाएगी। ऐसे केसेस आए बहुत सारे।
इस पर्टिकुलर केस में बस ब्लैक शिप वो कंसिडरेशन नहीं करते हुए
तो नौकरी मिलती नहीं है, अगर 302 चालू हो जाता है, वैसी दीवार हो जाता है बस। गलत नोटिस कर दिया करना। Yes.
Largely for hearing, the respondents have submitted their reply. They have telephonically informed me that he is on bed rest, actually get on bed rest. So he will not be able to appear, so he will be prepared for the listing after 3 weeks.
After 4 weeks. And come to complain. The learned counsel for respondent is unwell. List this case after 4 weeks. चलो next one.
Respondent is still trying to get a record.
My lord, record, I just received the record, man.
I have a record.
My lord, जो इससे पुजारी से संबंधित अपॉइंटमेंट से रिलेटेड जो प्रोसीडिंग्स चली थी एसडीओ रेवेन्यू के सामने, उससे रिलेटेड रिकॉर्ड बोला था डॉक्टर करने के लिए। द रिकॉर्ड इज अवेलेबल, आई जस्ट रिसीव्ड द रिकॉर्ड।
मेरे को तैयार हो गया फिर।
क्या पुजारी
मेरा सिर्फ इतना सा कहना है कि जो भी हम वहीं पर कर रहे हैं और हमको पहले अपॉइंटेज याद तो करा था कि हम लोकल जगह पर ही रह रहे हैं जहाँ पर मंदिर है, और उसी ऑर्डर और आपने
ठीक है सुनेंगे फिर। So we can learn counsel for the respondent state submit that the record is available.
Yes, ma'am.
Available. Matter is to be heard. Finally list of the week commencing 4th of March.
I have to continue.
I have to continue. 4th of March.
I have, if any, people.
Yes.
वही है बढ़िया।
I have to दोनों।
I have to continue. What is issued? About it.
महिला पूरा को डिस्पेच हुआ
जी
पूरा को डिस्पेच हुआ।
आपने ऑर्डर चैलेंज कर दिया?
महिला
कहाँ कर दिए? इश्यू नोटिस
Is 33 to 66 WP 1000 2000 yeah.
आप वकील साहब एंगेज करो। लास्ट टाइम आपको बताया था अमेंडमेंट एप्लीकेशन लगाना पड़ता है। जी नंबर लगाइए, आइए नंबर बताइए। अभी अमेंडमेंट अलाउ भी नहीं हुआ, एप्लीकेशन को अलाउ करवाना पड़ेगा। वकील साहब क्यों नहीं एंगेज करते आप? वो बराबर कर लेंगे। आपको नहीं मालूम है यहाँ का प्रोसीजर। लास्ट टाइम बताने के बाद में भी आपने फिर गलती कर दी है। एप्लीकेशन तो लगा ही नहीं अभी तक।
अमेंडमेंट करके लगी।
अरे भाई आप नहीं समझेंगे, हमने अमेंडमेंट अलाउ नहीं किया आपका कभी। आपको टाइम दिया था आवेदन प्रस्तुत करने के लिए, ना आवेदन प्रस्तुत हुआ, आपने सीधा अमेंडमेंट पिटीशन फाइल कर दी। आपको परमिट किसने किया अमेंडमेंट करने के लिए? नोबडी हैज परमिटेड। ऑर्डर शीट्स देख लो आप। डिसमिस कर देते हैं इसको। क्या करेंगे? कितने का टाइम देंगे आपको? वकील साहब एंगेज नहीं करना है आपको। जो आपको प्रॉपर लीगल एडवाइस देंगे उनसे आप बात नहीं करेंगे। अब आप फिर वकील बनना चाहते हैं यहाँ पे, दैट इज नॉट पॉसिबल।
अगर अमाउंट छोटा सा
अरे अमाउंट छोटा सा ऑर्डर को चैलेंज करो, जिसको आप मतलब जिसका कंटेंट आप बता रहे हो यहाँ पे, वो तो कुछ लगाया नहीं उसको, ना चैलेंज किया उसको।
है सब।
अरे भी चलो उसको फिर हम देखो, हम ऑर्डर पास कर देंगे डिसमिसल का। क्या करना है आप जल्दी बताइए। वी कैन नॉट एक्सप्लेन, वी आर नॉट हियर टू टीच एनीबॉडी। यहाँ तो हमको जल्दी इतना टाइम नहीं रहता, 2-2 मिनट का काम है, हम समझ गए करना क्या है इसमें।
टाइम
2 weeks टाइम टू फाइल अप्रोप्रिएट एप्लीकेशन फॉर अमेंडमेंट। अमेंडेड पिटीशन पहले ही फाइल कर दी, उठा लो। चलिए जस्ट आफ्टर 2 weeks लीव देने के लिए हम लोग बैठे हैं, पर उसको प्रोसीजर फॉलो करना पड़ता है, जो आपको मालूम नहीं है। यस
This is a contempt petition. The respondents never have the order.
This is issued. We have already issued notice.
They have filed the compliance report. The order which this honorable court taking cognizance of and issued the contempt notice. Have been submitted before this honorable court as compliance of the honorable court's order. उस ऑर्डर को देख के कंटेम्प्ट नोटिस जारी किए थे. रिप्लाई में कंप्लायंस रिपोर्ट में वही ऑर्डर लगाते हैं, बोलते कंप्लायंस होता है. Direction of your lordship was very categorical and specific.
Where is the order? Where is the order?
Passed by lordship.
जिसका कंटेंट बोल रहा हूँ.
Direction P1, my lord. It starts from page number 9. Operative party, page number 13 and 14. Paragraph 10. Paragraph 9 onwards.
Directed to reconsider the case of the appellant for
Making it to be honorable acquittal.
to be clean and honorable and pass an appropriate speaking order.
Yes, my lord.
So
They again say that it is benefit of doubt, no claim, and rejected my application.
Lord, may kindly see the.
It's not an equivocal.
अरे इस पे हजारों जजमेंट्स हैं सुप्रीम कोर्ट के.
Lord, the judgments are on the both the sides, my lord.
बोथ की साइड में जो हमारा डायरेक्शन है वो आप पे कंप्लाई करना है. गलत ऑर्डर है भी कंप्लाई करना है.
Has been complied, my lord.
Let me file SLP and bring a stay from the Supreme Court.
My lord, that has been complied by.
बताइए मैं ऑर्डर अप्लाई किया आपने.
10/10/2023.
पढ़ा आपने कि नहीं पढ़ा? मैंने लास्ट पैराग्राफ क्या बोला था कि it has to be treated as honorable acquittal. It cannot be benefit of doubt. And now we are again giving the same finding that benefit of doubt है, इसलिए हम इसको नहीं अवॉइड कर सकते. Can you do that? As a lawyer, please tell us, can you do that? आपके ऑफिसर को तो नहीं समझ में आता, वो तो चाहे IAS, IPS हो, they don't understand because they don't read the orders. If they start reading the order, they will definitely know what should be done. So बुला लेते हैं इनको, फिर we'll draw contempt against these officers. If they that वो आपका जो नोटशीट बना था, we are not the officers only.
Signing the.
जो साइन कर रहा है वो आके बोलेंगे साहब हमने देखा ही नहीं, तो बाबू ने बना के ला दिया, आपने साइन तो आपने किया ना. Such a simple thing, if you don't read the operative portion of the order, because they don't have time, वो सब हमें इसमें लगे रहा है, बुलाना पड़ेगा, बुला लेते हैं, कोई ऑप्शन नहीं बचता हमारे पास. देखिए इसमें earlier this court had issued notice to the respondents. तो डिटेल ऑर्डर करना पड़ेगा, सुप्रीम कोर्ट जाएंगे हम लोग. They will go to Supreme Court after we call them.
But the Honorable Supreme Court has said that it is not in every case. When this Honorable Court comes to the conclusion.
Why we are calling them to mention everything? ये बोल रहा हूँ मैं.
Deliberated.
So that इनकी SLP dismiss हो जाए वहाँ पे. ठीक है, निकाल दिया ऑर्डर. डिटेल ऑर्डर करना पड़ेगा. They will call the officers. Who is responsible for complying this order?
This order has been signed by the respondent number 2 on the basis of a letter passed by contender number 1. Contender number 1 directed him to do in this manner. So he wrote a letter to contender number 2, and contender number 2 eventually issued the order.
Both will have to be
The answerable number.
ठीक है, चलिए.
There will be three constructions in this matter last 15 and Rachel is identified about them and which one they
In this case, there is a stay on demolition of the construction which is on the national highway. And
they have all the respondents served or not?
Yeah, we have filed a reply and vacating stay application also. Notices were issued earlier, my lord, and there was a stay on the demolition of this wall which is the national highway. So it is not in the public interest, my lord. This can cause the accidents also, my lord. And after we have proceeded under the various acts, my lord, this is
Control of National Highway Act and also under Revenue, my lord, MPLRC. And we have found out that this is actually an encroachment. It's a fact-finding inquiry was there, and we found it's an encroachment.
You are a petitioner. Who is petitioner?
I am respondent. I filed application for vacating stay.
I am appearing on behalf of the petitioners. The notice was issued and the interim relief was given on 22/6/2023, my lord. And they have
This matter is listed on this mention memo, I suppose.
Yes, my lord. Because I filed vacating stay application.
Who is Murtuza Beza?
I am Murtaza.
You are concerned for petitioner. यहाँ लिखा है आपने.
I'm sorry, that may be a typographical mistake. Earlier, this honorable court directed to decide the representation after considering the reply. Decided that consideration, their representation, and
this is second round now.
And there was statutory remedy to file an appeal under that act also. In that appeal, that Control of National Highway of 2002 Act is there. I have reproduced the relevant provisions.
This is the problem. Argue. In pass it over.
My lord, they gave me 2 weeks time to file the rejoinder and then we'll argue it finally, my lord. And I would like to make a small correction, my lord, to what my learned friend has said. The construction is not on the road itself. There are photographs filed with the petition. It's on the side.
Place for time to file rejoinder. Week's time is granted. You file it within 1 week.
My lord, we'll file Wakalatnama and rejoinder.
Both within 1 week. Wakalatnama and rejoinder within 1 week. Give this case in the week commencing 26th. चलिए, I have to continue. Next is 45.
I know the petitioner here is an advocate Indore from 1991, 33 years. Now, he has been barred from practicing and even entering the court campus. He is not able to take cases, represent any of the client just because content number 2. They are having some kind of virtual prejudice.
वहाँ अपील होती है ना डिसिप्लिनरी अथॉरिटी की
स्टेट बार आई एम वेरी गुड स्टेट बार काउंसिल मानो तो वी हैव ऑलरेडी पास्ड अ फेवर ऑर्डर इन देयर फेवर मानो बट द डिस्ट्रिक्ट बार इज नॉट एक्टिंग ऑन इट मानो
compliance of order is still pending.
So what is the remedy?
We have chosen to file this petition against responding.
So the order, which is the order passed by the एक तो हाँ स्टेट बार ने क्या पास किया?
स्टेट बार का एनएचपी 1 का लगाया बस जो ऑर्डर किया हमने पेज नंबर एनएचपी 1
दैट इज इन अपील
डिसिप्लिनरी
कमिटी ऑर्डर पास बाय द डिसिप्लिनरी कमिटी Bar Association, can they take a decision to debar any advocate? They can.
They are surprisingly not doing it even after the orders filed by the state bar ones.
You are appearing for whom?
State bar.
State bar.
Yes, madam. Number 2 is not complying with.
Notice is not issued.
Issued.
Sir.
It is 8/11/2023.
Direction will be issued to the follow this instruction.
Direction you have to tell them, otherwise they will never comply. It's a question of bread and butter of this advocate.
Due to doing loss of that.
बैठते हैं गेट के बाहर अंदर
मैनेज कार एंड
कार भी अंदर नहीं जा सकती ना कब बाहर खड़े हो
But even he is not allowed to represent anyone. And his cases are being taken.
Number 2 is not allowing.
Yes. And his cases are being taken without any NOC or anything.
My lord, one idea number 6134 of 2023 was filed with the petition. It has partially become infructuous. As the election have already been held in November.
Nobody is appearing on behalf of number 2. इसको बुलाओ फिर से बुलाना पड़ेगा.
President of the
आपके स्टेट बार काउंसिल के ऑर्डर से तो दे कुड हैव फाइल्ड बार काउंसिल ऑफ इंडिया के सामने जाना चाहिए था उनको. उनको क्लियर कट डायरेक्शन है कि उनको अभी वकालत
करने के लिए कहा है.
बहाल करने के लिए कहा है और उनकी बैठक व्यवस्थित की जाए. इसमें लिखिए लर्नेड काउंसिल फॉर पिटिशनर. इसमें अगर लिखिए द नोटिस टू रेस्पोंडेंट्स इज सर्व्ड. Respondent number 2 is served. Even though the notice to respondent number 2 is served, no one appears for the respondent number 2. The grievance of the petitioner is that, in spite of order having been passed by, order dated P1.
18/3/23. Election P1.
19/6/23.
18/3.
अच्छा ये आदेश है पूरा.
जी.
Forwarding and
communicate
in spite of the order dated 18/3/2023 passed by the State Bar Council of Madhya Pradesh, Jabalpur, which has been forwarded by the order dated 19/6/23, the petitioner is not being allowed to
appear in the course.
Carry on the profession of advocacy at the behest respondent number 2. इनके कहने से नहीं हुआ. रेस्पॉन्ड नंबर 2 full stop, which is violating the fundamental rights to carry on the profession, and the petitioner is facing due to the financial problems. ठीक है. In view of the aforesaid, the अध्यक्ष सेक्रेटरी इनका क्या नाम है?
अजयपाल सिंह जादौन अध्यक्ष. P10 पे लिखा सही है. P10
letterhead of the parties.
The president SHRI Ajaypal Singh Jadon and secretary Shri Pritam Rana of the District Bar Association Shujalpur shall remain present before this court on on 28th of February 2024. The registry is directed to send a certified copy of the order to the District Bar Association Shujalpur for information and necessary action. List this case on 28th of February. Yes, next.
On the last date of the hearing, Honorable Court will be directed to submit the copy of provisional order, attachment order, and the copy of appeal memo. Some 8 or more than 8 property has been attached by the ED, against which he is commented that some properties belongings to the reply file. So reply file होगा पर वो order just now I am receiving that order. So I want to submit that all the orders. Provisional attainment order. Because of that reasons की 8 order हुए provisional attainment order की property के इसमें इन्होंने appellate authority को he has filed an application to appellate council for respondent prays for time to submit that the additional copies of the provisional order has been received by him today and prays for time to file the same list in the next week.
Maybe after 2 days.
right?
It is, sir, matter is pending.
So we have to also amend the pleadings. Because of that reason, these orders must also be come on the pleading.
But don't buy my argument. That depends on once you file it, once you serve it, then I will exercise my claim. Sir, my respectful submission is the learned counsel is required and mandated to serve and file in super order 2 of 2000.
Next week. Next week. I will get it. Who's next?
47.
Yes.
Certain notices have been served, reply is awaited.
But this petition is not mentionable because they are challenging the sanction for prosecution.
First, I am challenging three things. Number one, that there is no material sanction should be obtained. Second is the sanction itself. And third is for removal of.
जजमेंट है ना कि sanction refusing or granting sanction के नहीं
Can be challenged before only trial court.
हाँ
So,
trial court.
that is just one of the reasons. The main relief is my name should be removed at the time because there is no material.
That cannot be done here.
There is no material against me. So मेरा नाम इनको appeal
ट्रायल कोर्ट के सामने जाइए ना सीधा सीधा क्या कह रहे हैं आपकी sanction the improved sanction for prosecution.
that is but
So this goes in the light of judgments. ठीक है? Do you agree?
one I am withdrawing the plea.
Then second, decision to appeal, we cannot decide in this writ petition. रवि लगाइए सब जो भी लगाना है।
226-27 क्या होता है? संक्षिप्त उसका 226-27 में लगता है कि उसको डिस्चार्ज होती है।
226-27 जो है ना 227 CRPC में उसमें you can make an application for discharge on these following grounds. And if some order is passed, then that is revisable or inferently you can come.
I am on probation.
We cannot cut short the trial like this, saying that after draft कर दो.
As soon as charge sheet will be filed, I will be terminated. So I am
Before framing of which this we can make a raise an objection.
as soon as charge sheet is filed.
अभी नहीं पहले
अभी नहीं हुई.
अभी charge sheet फाइल है and मेरा जो नाम है
तो डिस्चार्ज तो एक्सपोर्शन 70%
just kindly give me a minute कि मेरे against material कुछ है ही नहीं. मेरे
तो आपके खिलाफ आपके पक्ष में रिपोर्ट भी तो आ सकती है।
मैंने एक रिपोर्ट ऑलरेडी बनाई हुई है एनेक्शल A5 उसमें उसके बेसिस पे दे आर सीकिंग सैंक्शन फॉर प्रोसिक्यूशन काइंडली जस्ट लुक एट पेज नंबर 41 लॉर्डशिप
We cannot go into the question of prosecution sanction. बताओ
मटेरियल ही नहीं है सर मटेरियल ही नहीं है देखो ना
नीचे क्यों नहीं लगा रहे एप्लीकेशन क्या प्रॉब्लम है आपको?
जो सैंक्शन है उनको लेना ही नहीं हो
चार्जशीट अभी पर्सनली कोई सैंक्शन के लिए अप्लाई किया 70,000 रुपया प्रीमेचर होगा अभी मेरे हिसाब से तो प्रीमेचर होगा
तो जो लोग इसका पूरा प्रकरण है इट इज ब्रेक द डेट
This action would not amount to मतलब प्रीमेचर नहीं होगा ये.
It would be, my lord, that original competent court has not applied its fine, and before that, my lord, it has taken in a judicial review under Article 220.
That is what. So when judicial review is not permitted.
Yes, and this is not a case where, my lord, this is divorce the jurisdiction, my lords, because otherwise, the prosecuting agency can always seek sanction. Sanction granted, validity of sanction, that is again subject to judicial review, but that too, my lord, subject to the competent court. So therefore, my lord, rightly usurping that jurisdiction in 226.
With the liberty you operate the court trial court.
टाइम गिव मी आर्टिकल 226 वॉशिंग का रिलीफ भी मांगा जा सकता है इफ देयर इज अ क्लियर अब्यूज ऑफ प्रोसेस अब्यूज में 1 मिनट में आई एम गोइंग टू डेमोंस्ट्रेट लॉ सर इफ यू पॉइंट काइंडली लुक एट पेज नंबर 40
ठीक है आपको बहस करना है तो लंच के बाद करिए. विल पास अ डिटेल्ड ऑर्डर देन. यस मेंटेनेबल नहीं है वो सैंक्शन के खिलाफ.
सो सैंक्शन वाला रिलीफ में विड्रॉ कर रहा हूं सो रेस्ट ऑफ द रिलीफ
बाकी जो सब डिस्प्यूटेड क्वेश्चंस ऑफ
अनडिस्प्यूटेड
बताइए नेक्स्ट आफ्टर लंच बताइए.
लॉर्डशिप वो मेंशन में निकली में गया तो लॉर्डशिप रजिस्ट्रार साहब के बाद उन्होंने बोला कि मेंशन अलाउ करवा के लेकर आओगे तो भी हम आगे प्रोग्रेस कर सकते हैं आगे.
कल की लड़ सकते तो तुम्हारे को लड़ सकते
आज के लिए कहाँ पे हो गई?
अब आज नहीं तुम्हारे लड़ Lordship, on the basis of only undisputed facts, जो कि बहुत ही छोटे हैं, facing my arguments. Lordship, can you look at page number 41? 41 में entire summary of what the matter against me है. उसमें जो ऊपर वाला पैराग्राफ है लॉर्डशिप, उसमें नीचे से में कौन सा है ये? सही डॉक्यूमेंट A5 वो क्या है? सर दिस डॉक्यूमेंट इज द प्रतिवेदन, आपका उनका जो प्रतिवेदन है उसी की पूरी इन्वेस्टिगेशन तो उसके लिए प्रतिवेदन उसमें लॉर्डशिप नीचे से छठी लाइन में मूल फाइल का मिलान कार्यालय में रखी सुरक्षित सत्यापित फाइल से करने पर नोटशीट पृष्ठ क्रमांक 1 की द्वितीय अंतिम लाइन में क्रमांक के पश्चात रिक्त स्थान पर 456 एवं दिनांक के पश्चात रिक्त स्थान पर 1/3/19 लेख किया जाना पाया गया है, जिस पर दिनांक 20/12/2022 को आवेश श्रीवास्तव द्वारा स्वयं के द्वारा लेख किया जाना बताया गया है. This is the only allegation against me. Now, Lordship, kindly look at page number 2. Page number 2 is the chronology of what happened. ये पूरा लोकायुक्त का प्रकरण मेरी नौकरी ज्वाइन करने से पहले का है लॉर्डशिप. मैंने नौकरी ही ज्वाइन नहीं की है जब एफआईआर दर्ज हुई, जब ये ट्रैप केस हुआ. जो मेन एक्यूज्ड है हरियन पचोले, वो नौकरी में था उस समय. इसके 1 महीने बाद मुझे कंपैशनेट अपॉइंटमेंट दिया डिपार्टमेंट में. उसके 6 महीने बाद रिस्पॉन्डेंट नंबर 5 ने, रिस्पॉन्डेंट नंबर 4 ने मुझे ऑथराइज किया कि लेना में मामला रखते हैं. ये मामला है ज्वाइन होने के पहले ही ये केस फिर हो गया था. पूरा ट्रैक कार्रवाई होगी थी बस बिफोर आई जॉइन द ऑर्गेनाइजेशन. केस क्राइम नंबर 4/2021 को रजिस्टर हो गया. ये अपॉइंटमेंट इसका 1/11 को हो रहा है. सर इसको कर सकते हैं, इसको पहले हो गया. हाँ, केस तो रजिस्टर पहले ही हो गया है. पहले ही सर, तो इतना आर्बिट्ररी एक्शन है. देन वी कैन इंटरफियर मिस्टर. सर काइंडली मैं ये देखें सर, काइंडली मैं 1 मिनट पूरी समझ. हाँ बताइए. अब इसमें 1 महीने बाद मैंने ज्वाइन किया. इसके 6 महीने बाद रिस्पॉन्डेंट नंबर 4 ने मुझे ऑथराइज किया किस चीज के लिए? लोकायुक्त में पड़ी जो फाइल है उसको मैं सुपुर्द में ले आऊं. उसकी 2 कॉपी बनाई गई, एक लोकायुक्त के पास रही. हर पेज पे मैंने सत्यापित किया. एक कॉपी मेरे पास रखी. मेरे पास जो रखी हुई कॉपी थी उसमें रिस्पॉन्डेंट नंबर 4 ने मेरे को कहा कि उसमें जो भी कमियां हो वो आप क्लियर कर देना ताकि हम जो कंप्लेनेंट है उसको पेमेंट्स कर सके. और कमी कितनी थी? फ्रंट पेज में ऑर्डर नंबर और डेट नहीं थी सर. और वो डेट और ऑर्डर नंबर तो रेस्ट ऑफ द फाइल में सब जगह लिखी. पेज नंबर 11, पेज नंबर 14 सब जगह है. मैंने बस वहां की जो इधर में क्या किया आपने एडिश, मैंने बस सब फ्रंट पेज में वो जो पेज में मैंने नोटशीट दी लॉर्डशिप, उस नोटशीट के लास्ट लाइन में 456 और दिनांक लिखने से मैं एक शादी बन गया सर. और ये जो फिगर्स हैं ये कोई गलत फिगर्स हैं, किसी को बेनिफिट देने के लिए दिए हैं, एक्यूज को हेल्प कर रहे हैं, कहीं ऐसा कुछ भी ऑब्जर्वेशन नहीं है सर. This it's already in the file. मोबाइल की फाइल में ये फिगर्स कहीं पे दे लिखे हो. ये जो इन्होंने ए साइड का जो प्रतिवेदन दिया सर, उसमें पूरे प्रतिवेदन में लाइन क्या कुछ भी एलिगेशन मेरे अगेंस्ट में. सर मैं यहाँ हाईकोर्ट क्यों आया? मैं तो ट्रायल में भी ये सिद्ध कर रहा हूँ 100% आई विल बी एक्विटेड. लेकिन सर मैं एक प्रोबेशन पे एम्प्लॉय हूँ, मेरे को कंपैशनेट अपॉइंट मिला, अभी नौकरी ज्वाइन की है, मेरी फैमिली को बहुत जरूरत है इस नौकरी की, अपने अलग टर्मिनेट हो गया. जैसे ही चालान पेश करें मैं तो टर्मिनेट हो जाऊंगा. इसलिए हाईकोर्ट एंड मैं सिर्फ इस अनडिस्प्यूटेड फैक्ट की बेसिस पे यहाँ आया. इट इज अ वेरी आर्बिट्ररी एक्शन on the part of state authority, and hence I can oppose this under 126.
We will file the reply and maintain the case diary also.
And data file respondent number 4 notices were issued, madam. Respondent number 4 should is also required to answer this because they have granted sanction.
Who is respondent number 4?
The authority which has granted sanction.
Municipal council. Notice हो गया ना?
हाँ, notice हो गया.
If he करना है तो I may be permitted to file an appropriate amendment for that object. In the meantime,
ऐसे ही कर दो उसको. क्या है?
ऐसे
लिखो उसको. क्या है ना? पार्टी में इसको अपन में.
वहाँ पे सर रिलीफ नंबर 2 में वो बाई मिस्टेक A2 और डेट आ गई. डेट डिलीट होनी और A2 के बजाय A3 होना.
डेट क्या होना?
डेट उसकी 1/2/23.
नहीं वैसे भी कर सकता हूँ, करता है इसको। जैसे अपन प्रमुख कर देते हैं, छोटा सा है। हाँ तो इसलिए क्योंकि उसको कोई गलत कुछ नहीं है। इसमें लिखिए Eleventh counsel for petitioner submitted that in para 7 clause 2 of the relief.
Yes.
Relief rate form. The date is mentioned as 19/1/23, bracket में annexure A2. Instead of the opposite, the correct date is
1/3/23.
1/3/23, annexure A3. A3. Therefore, he may be permitted to amend the
Relief part.
prayer clause. Full stop this. In view of it appears that the typographical error has crept in, therefore, we allow the amendment for which no separate application is required. The petitioner is directed to amend the clause 7.2 in the code itself. ठीक है, फिर उसके बाद में counsel for respondent is granted 2 weeks time to file the reply. Respondent number
2 and 3, man.
3 is granted 2 weeks time to file the reply and to produce the case diary. This after 2 weeks. Okay.
Lordship, this is the previous status petition on the last date of the hearing. Lordship was pleased to issue notice to the respondent number 5. Lordship, the notice was answered as per the status right here.
Yeah, let's fill out instructions, unsolved.
Yes,
Then. Yes, what about the status report?
One of the no status was called as for the previous order statement. Since it is the matter when the petitioner knows the whereabouts of the wife, otherwise not maintainable when they know if she is living with some other man, they should have filed section 9 application before the trial. And they are still married. The restitution is not maintainable since they are already married, they are not divorced, and Lordship, as per in section 9 application before the Lordship, as per the last my instructions, the wife and the 2-year-old daughter has called the petitioner and the brother-in-law of the petitioner, stating that the this respondent number 5 has unlawfully restrained them from coming back to the petitioner. On that ground, Lordship, this purpose petition is maintainable, Lordship. And already, Lordship, the petition was filed in the month of November 2023. Already a 4-month delay has been caused in bringing the corpus to the court. They don't even have a status report as of now. Since there is no order by the Honorable Court, so the blame cannot be shifted to us. As per the order sheets, it was listed for amendment in the petition itself. There was no erection of the Honorable Court. With my humble submission, Lordship, they may be instructed and status report may be called in the next week.
Illegal confinement कैसे हुआ ये? How do you say that it is an illegal confinement?
Lordship, since the wife and 2-year-old daughter, she called the petitioner and the brother-in-law of the petitioner and stated the fact that she has been unlawfully restrained from coming back to the home. The respondent number 5 is a resident of Bhilwara, Rajasthan, Lordship. I filed an amendment application also, as Lordship stated in the last order. IA number 888-7, Lordship.
888-7 was allowed.
Yes, Lordship. And I have carried the
सिर्फ ऐड कर दिया आपने, ये सब कहाँ लिखा है आपने कि ये illegal confinement में? Number 5.
One more thing, had there been a case that the petitioner received a phone call, they should have filed a complaint and got the FIR. I filed a complaint also, Lordship. Lordship, may kindly see Annexure P4. Oh, that is the missing person.
This is only missing person.
No, Annexure P4, I filed a written complaint to the.
इसमें writ petition में कहाँ लिखा है illegal confinement कोई word है use? पहली petition.
Kindly, Lordship, may kindly see page number 18, Annexure P4.
In the petition.
In the petition also I have stated, Lordship.
Respondent number 5 को तो बाद में आपने include किया उसमें.
Lordship, may kindly see facts, para number 5.5.
that until recently the petitioner came to know his wife and his daughter has been forcibly being kept by this person Sanjay, son of Dayaram. It is submitted that thereafter the petitioner submitted a written application before respondent number 4 stating his grievance. And till then no action has been taken by the respondent number 4 also. Despite of a written complaint to the police station, no cognizance has been taken on the real file, but so far as the elevation of election is concerned, page number 6 may kindly read of the petition. There is no problem in calling the status report. We will call it within a week, my lord. Page number 6. It is there reading itself. In charge police station, Ladakh district, Chittor, Rajasthan. It is further submitted that after missing report, the petitioner was informed by the concerned police station that his missing wife has given a statement and that she doesn't want to live with the petitioner and is living with other one, Sanjay, son of Dayaram, along with the daughter Lakshmi. That so cannot say that no action was taken. This is the action taken. So this was the action taken by the Chittorgarh police earlier. Also, on the last date of the hearing, the same facts was stated by me. And this was the clear dispute. Lordship, in the 2022, it was a matrimonial dispute. But in recent, as per recent facts, it is not a matrimonial dispute and an unlawful confinement. Earlier, it was matrimonial dispute, and that's why I have also stated in the fact 5.4 of the petition. Just mention Garbo. Next time to the status report. Just after 2 weeks. What about you? 49. Please, Lordship. These are the data pools regarding the land acquisition of the agricultural lands for constructing a new road, that is RW1 from Barganga to ISBT. The notices were issued. I guess my learned friend is here for Indore Municipal Corporation. The replies are still awaited.
My lord, this is a writ appeal, my lord.
Reply must have been filed in the
Next date also, my lord.
next. In what reply?
The objections, if any, or I am ready to argue the matter. But I wish to peruse the records of case number 49.1, that is Subhash, son of Balram versus State of MP. There are two important documents which needs to be perused.
Number one, this certificate is not acceptable to the petitioner, then they may approach the civil court under section 387 of the Municipal Corporation Act. The civil court shall decide the amount of compensation.
But that section 387 shall be applicable upon us if the actions were taken by the municipal corporation under the light of section 305, 306, 307 for widening of an existing public street or road. My humble submission before this honorable court is that there is no existing public street or road. Number one. Number two, the factual metrics of the case which were relied upon by the Indore Municipal Corporation before the writ court, before the learned single bench, was with respect to a land which was already there in the vicinity of the city, adjoining to an existing road, popularly known as AB Road in Indore. Then is a different case. For this matter, kindly see at page number 35, that is annexure P2 of the writ petition. This is a letter issued by Superintendent Engineer to the HON'BLE at page 35, petition Subhash versus State 49.1.
Reply किसका आया था?
Municipal Corporation.
Municipal Corporation.
Municipal Corporation.
Correct. I'm reading page number 35, the relevant part. विषय RW1 बाणगंगा रेलवे क्रॉसिंग से ISBT तक सड़क निर्माण करने बाबत उपरोक्त विषयांतर्गत लेख की RW1 बाणगंगा रेलवे क्रॉसिंग से ISBT तक सड़क निर्माण कार्य प्रारंभ किया जाना है. The words are very much important. The facts are very much important of this case. The words are प्रारंभ किया जाना है. It means that there was no existing road on that particular piece of land. क्या प्रारंभ? Widening or construction of the new construction? RW1. This construction was proposed in the meeting which is annexed as annexure P1, page number 31. Meeting was held jointly between IDA and the Indore Municipal Corporation. That is why both of them have been added as respondents.
Point number two, MI 4,
387 is not applicable.
my in the submission is, my lord, ki I am not a particular person whose existing house, shop, building, warehouse is coming into the road or is coming into a public street. Mine is an agricultural land. I have also annexed the photographs in the reputation itself.
AC चालू है, पंखी खोली, बंद करो.
Mine is an agricultural land. Had it been a case that mine is also a residential property, a commercial property in the vicinity of a city coming in the main line of the particular thing, street, I could have readily agreed with the Land Council over here for the municipal corporation. But the wordings of 305 and 307 are to be read before considering 387, because 387 says when the compensation has been supposed to be paid under this particular act, for the damages to be sustained for the purpose of 307, 307, 5 and the other similar provision. But mine is a fresh acquisition. And since I'm reading Annex P2, there is one more specific line which I would like to point to your lordships. Line number 2 of the same page. सीमांकन उपरांत सड़क चौड़ाई में संलग्न सूची अनुसार आ रही निजी खुली भूमि का अधिग्रहण नियमानुसार किया जाना. The words they themselves are using is acquisition. It is not a case of widening an existing public street or widening of a public road.
It doesn't say new construction, new road construction.
It is completely a newly proposed road because there was no such road on that particular area. Mine is an agricultural land.
नीचे रिप्लाई में दिया था.
But furthermore, we are issuing me the compensation certificate as per Rule 61 of Madhya Pradesh Bhumi Vikas Niyam 2012. This compensation certificate is at Annex P3, page number 37.
Compensation certificate has been issued.
It has been issued, but it is really erroneous on the part of issuing the compensation certificate.
Compensation certificate is issued, then your remedy is 387.
But the compensation certificate is this so-called Kshatipurti Praman Patra is regarding an FAR. And how does the concept of FAR would apply to an existing agricultural land? Something which cannot be digested. They are acquiring a fresh piece of land for constructing fresh road. There was no existing public street or there is no widening of a public street as such. I am not obstructing to their construction of RW1. I am readily giving them my land, but only my request is that I should be properly awarded the compensation as per the Land Acquisition Act.
Land acquisition buildings never took
place. They never took place. Section 6, 11, nothing. The only thing which they relied upon is the rule number 61 of the Bhumi Vikas Niyam. The relevant portion I have reproduced there in the appeal. Page 8, ground 3.1. If you lordship could produce rule number 61 of Bhumi Vikas Niyam, it talks about floor area and height limitation. Floor area ratio, the floor area ratio FAR for different use groups shall be mentioned in table 8. Then it provides residential, commercial, public, semi-public.
Say whether they have issued section 4, section 6.
That is not done, my lord. They have to do it in case of a street which is specified in the master plan, my lord.
But my point is that there is no existing street on the ground. Just simply by relying on this particular aspect that this is something which we have notified in our master plan, which we propose to do in the near future. How can it be considered to be widening of an existing street? 305, 307, the wordings are very much clear with respect to the buildings which are coming on the existing. There must be an existing street. The judgment which is relied by our learned friend, I will come up on that, but first I would like to bring to your notice this FAR. There is more from the well in this FAR. In case where the owner surrenders a portion of his land, the word used is surrender. But I have never surrendered my land. How am I supposed to be eligible for getting twice the FAR? Plus, the FAR can be used as they only mention residential, commercial, public, semi-public, and industrial. Mine is a purely irrigated agricultural piece of land. What am I supposed to do with that FAR? Am I supposed to buy a new plot of land and then go before the IMC to beg, please provide me twice the FAR which you used to provide me because my land has been erroneously acquired by you, and then construct upon it, and then utilize a particular piece of land?
First point, note 1.
61 का.
Yes, ma'am.
Okay, floor ratio, area ratio.
Floor area ratio. This is with respect to development of his land.
The owner surrenders a portion of his plot land and vests its ownership in the government.
That is when I willfully do it.
For public purpose, an additional floor area adding twice the area of plot land surrendered by him will be allowed in the remaining area of the plot in lieu of monetary compensation.
Exactly. That is when I willfully surrender my land. I am not willfully surrendering my land.
Then they have to follow the acquisition procedure.
That is the only relief which I am claiming. You may acquire my land for the public purpose. I am not a person, I am not a busybody who is objecting to the sustainable development.
They can acquire provided they follow the procedure.
They can acquire. There have to be a procedure followed as per the Land Acquisition Act. That is a central legislation which prevails all over these state legislations. And so far as the judgment which was relied upon.
क्या प्रोसीजर है नगर पालिका में आपके?
सर नगर पालिका में ये प्रोसीजर है सर. Once there is a master plan, my lord, we publish a draft master plan. The town and country planning department does that in by virtue of section 17 of the Nagar Tatha Gram Nivesh Act. Under section 13, my lord, the town and country planning department specifies all the roads which are to be widened, even the roads which are to be constructed in the near future. That plan is published. Objections are invited against that plan, and thereafter, my lord, the final development plan is published. By virtue of section 25, read with section 19(5) of the Nagar Tatha Gram Nivesh Adhiniyam, from the date of its publication, that master plan is binding upon the corporation, including the owners. So even the new streets are incorporated in that plan, and we are under a bounden duty to construct those roads, my lord. Now, once a road has been specified in the master plan, my lord, we are not required to follow the procedure of Land Acquisition Act only to the extent.
No, it's not required that.
It's not required, my lord, because there is a specific provision when in respect of public streets notified in the Municipal Corporation Act, read with the provisions of Nagar Tatha Gram Nivesh Adhiniyam. And those provisions have been interpreted, my lord, again and again in various decisions of this honorable court, which have been affirmed by the Supreme Court in the case of Ravi Ramchand Malparyapal. Now, what the petitioner is contending, my lord, it is a case of widening of road, and not of a road which is not in existence. Our case is, my lord, that even for the roads which are not yet in existence but have been notified in the master plan, same procedure is followed. And it is not like we're not paying any compensation, sir. The compensation adjudication is delayed after the possession is taken. That is the striking difference between those procedures. Because Land Acquisition Act, my lord, it has two aspects. First is that you can file your objection regarding non-inclusion of your land because it's not a public purpose, etc., etc. That exercise has been taken care of by the virtue of provisions of the Nagar Tatha Gram Nivesh Adhiniyam, where their objections are invited, and overwhelming all the objections that land has been notified. Now, only the adjudication of compensation will come after the possession has been taken. And as per the language of 305 and 306, my lord, the word uses reasonable compensation. Now, the word reasonable compensation has been interpreted to mean that reasonable compensation can also be FIR, warrant of FIR. And if you are not satisfied, if you cannot utilize that FIR, there is a procedure, 387, under 387, you approach the Panchayat of the Nagar Nigam. If you are not satisfied with the decision or when the Panchayat does not take in decision,
Note number 1, in the owner surrenders.
these are 61 is only for the basis of principles. 61 is not applicable. The provisions which are, these are all written in the judgments, my lord. That's why, because there are three. Bhumi Vikas Niyam,
कहाँ judgments कहाँ हैं?
judgment है सर. ये लीजिए. Although I know it's a very lengthy judgment, I'll just read out the relevant paras for you.
बताइए कौन कौन सा पैरा है?
May I read my? May I read my lord the relevant paragraph?
Today we will not decide. We will also like to go through this first.
May I please mention the relevant paragraphs
सर बहुत दिक्कत हो जाएगी.
so that your lordship
Before getting into the judgment, my one humble submission, you may kindly refer to the section 305, which is giving them the power to widen the road and construct the road. I am not objecting to the construction of the road. What I'm clearly bringing before this honorable court is that I should be awarded compensation as per Land Acquisition Act because this is not an existing road. I will kindly produce section 305 of Madhya Pradesh Municipal Corporation Act 1956, power to regulate line of buildings, subsection 1. If any part of a building projects beyond the regular line of a public street, the word is public street, either as existing or as legitimate for the future or beyond the front of immediately adjoining buildings. The word again uses buildings. The corporation may, if the projecting part is a veranda, step or some other structure external to the main building, then at any time, or if the projecting part is not such external structure as aforesaid, then whenever the greater portion of such building or whenever any material portion of such projecting part has been taken down or has fallen down, require by notice either that the part, some portion of the part projecting beyond the regular line or beyond the front of the immediate adjoining building shall be removed, that such building when being rebuilt shall be set back to or towards the said line of front and the portion of the land headed to the street. Such setting back or removal shall henceforth be deemed to be part of the public street and shall vest in the corporation. Provided that the corporation shall make reasonable compensation to the owner for any damage or loss he may sustain in consequence of his building, any part thereof being set back. Where is our agricultural land? Not even a whisper about agricultural land. This is the thing which I am stating right from day one. That the factual matrix of the Ravi Ramchandran Wagmare versus IMC was an existing house. In municipal corporation में कहाँ damage का? Damage मतलब circumvention का. For this particular provision, they are providing compensation for under section 387. 387 reads arbitration in cases of compensation, etc. If an agreement is not arrived at with respect to any compensation or damages which are by this act directed to be paid. उसके लिए आपको वहाँ जाना पड़ेगा, district judge के पास apply करना पड़ेगा. But my humble submission is that mine is not a case which is falling under 305. I can claim a compensation under 387 only when my case is falling under section 305. Mine is not an existing building. Mine is not a shop. बताइए ना. Yes, madam. कहाँ प्रावधान है कि नई सड़क बनाने के लिए अगर नगर निगम सीमा क्षेत्र में है तो उसको अच्छा भू अर्जन किया जाएगा. मतलब सेक्शन तो था नगर ग्रामीण परिषद में वो डिलीट हो गया मध्य प्रदेश में. My humble submission is that they are acquiring my land. I'm not obstructing their acquisition. What I'm saying is they should acquire it under the Land Acquisition Act. Because granting me an FAR as per Rule 61, which they say only for the wordings, their compensation certificate specifically relies upon Rule 61. We'll hear it some other day. Let us talk for 2 weeks. IR is no? IR is there. I have to if there is one writ appeal which got listed today itself because there was some defect, writ appeal number 15 of 24 Gendala, in which the notices were not issued and the IR was not issued because there was a defect which I have duly cured. So, the IR may kindly be granted. There is IE number 405 of 2024. Gendala 49.4. 49.4, madam. दूसरे में क्या ऑर्डर लिखना किसी मेल केस में रिट अपील नंबर 15 ऑफ 2024 सबसे पहले वो आपको नहीं ये तो 15 है तो 15 गेंदाला आईए नंबर 405 ऑफ 2024 दिस इज एन इंटरलॉक्यूटरी एप्लीकेशन फॉर स्टे. इसमें आईआर कहाँ है इसमें? मतलब इसमें आईआर नहीं है बिकॉज़ ये आज ही लिस्ट हुआ है. इसमें स्पेशल एमआई में भी आईआर नहीं है. बट देयर वाज अ कॉमन ऑर्डर व्हिच वाज पास एंड दिस ऑनरेबल कोर्ट डायरेक्टेड टू कीप द ऑर्डर्स ईच ऑफ द फाइल्स विद द रजिस्ट्री. आईआर वाला ऑर्डर कौन सा है? आईआर वाला ऑर्डर है सुभाष बलराम रिट अपील 3 ऑफ 2024 द फर्स्ट वन व्हिच आई वाज आर्ग्यूइंग. नहीं इसी में नहीं आई यार. मतलब आई यार नहीं है ना. सुभाष बलराम में भी यार
Writ appeal number 5. Order dated 22/1/2024.
बाकी किसी में नहीं है, एक में है.
My lord, otherwise, when the notices were issued, your lordship had ordered that in order passing this writ appeal 5/2024, and the similar line of action were there.
ये ऑर्डर करना है इसको. WA5 वाला ऑर्डर करना. सभी में करना पड़ेगा.
Yes, sir.
Sir, वो construction.
All of them are being undertaken under status quo.
So my lord will fix an early date.
Least in the week commencing 11th of March. ये सब नए नए केसेस नहीं सुन सकते अभी. अभी राइट की
Sir, settled as per.
होगा सेटल, पर इतना टाइम नहीं है हमारे पास. Here all the cases and then here the old cases and
If the road construction was not taking place,
आराम से सुनेंगे. अभी स्टेटस को अभी दीजिए तो देखेंगे. यस यार मेरे कंट्रोल जा रहा है वो.
Lordship, I'm requesting for next week, my lord. My lord.
Writ appeal.
Yes, ma'am.
What are you challenging?
Lordship, I am challenging order dated 10/1/2024, annexed A1. Lordship, there was a judgment passed by Honorable Jabalpur bench in UP 21051 of 2023. To the contrary, this judgment has been passed on this petition, my lord. Lordship, basically the facts of the case are that a committee was constituted, which is respondent number 3 before your lordship.
क्या CEO was not appointed under section 23 of the Work
Yes, my lord.
Act.
Yes, my lord. And my lord, further
क्या होल्ड किया डिवीजन बेंच ने? Single bench.
Single bench ने वहाँ पे my lord जो order है lordship, it says that it has quashed the appointment of the
CEO.
yes lordship.
And on this ground alone.
It has quashed the appointment of the CEO. Further, it has my lord. My lord, it has also quashed the appointment of the president of the committee also. Yes, it has.
But the CEO has not been appointed.
I'll address my lord on the next date on the same point, lordship. That is why I'm seeking an adjournment.
So we can also need to argue the matter list after a week.
Grateful, my lord.
Yes. Supplementing list चाहिए.
But the fresh notification for another 3 days has been issued, my lord. So the presiding officer would not be available for up to 21st now. Today there is a new notification that he is not.
What have you challenged now?
My lord, I am challenging the disposition proceedings, my lord, on the ground that the order that has been passed does not indicate properly the four corners of the land which is to be taken in possession, and all the more, the bank itself has agreed that it has been erroneously issued on all counts. The amount is wrong.
Auction हो रही है.
My lord. Auction अभी हुई नहीं है. Auction हो रही है. मेरे को in the light of that I may be dispossessed, my lord. So only to the extent that my application may be heard by the DIT. Till that time the disposition should be stayed. That is only my anxiety. My lord.
File any proceedings before the ऐसे file किया है.
ऐसे file किया है, that is pending. And because of the non-availability, my application for urgent hearing on that got be heard. So, and before this honorable court, the Annexure P5 was another petition that has been entertained by this honorable court.
Annexure
P5, my lord, at page 68. My lord pleases to protect me on the similar terms.
Well, when did you file this essay?
The essay is pending, but I filed a copy of the essay also. The date of filing is pending, my lord. Yes, my lord. The date of filing is December 22, my lord.
December 22.
Pending since then. Yes, my lord. I had challenged the original notice of 13 itself.
अपने भी किया था अभी. Last week किया ना एक बार. ऐसे ही कर रहे हैं.
एक वकील साहब की नॉन सडन डेथ हो गई था। अटैक हुआ सर,
पता चला।
और उस समय भी सर चूंकि एम्बुलेंस वगैरह था यहाँ पे एडमिट के
बुला कलेक्टर को, सीएम है तो सर बीच में खड़ी तो रहती थी एम्बुलेंस।
सर वो आती है।
पर ऐसा है कि जो मेरे को इन्फॉर्मेशन मिली वो 1-1.5 घंटा पहले उनकी डेथ हो गई थी, वो गाड़ी के अंदर बैठे हुए थे सर। somebody saw it।
नहीं सर ऐसा इशू नहीं था, पुलिस नहीं भटकर साहब की वाइफ ने उसको इंसिडेंट को देखा था। एक्चुअली क्या है, जब वो गाड़ी की तरफ जा रहे थे तो वहां से उनकी स्थिति थोड़ा खराब होना शुरू हुई।
एक बार कार से लेके गए, तुरंत लेके गए।
फिर सर उनके सामने एक कार और खड़ी थी, वो भी एक इशू हो गया। दूसरी कार आई और दूसरी कार ने फिर उनको वहां से नहीं करा, लेकिन उस बीच में एम्बुलेंस के लिए भी सर्च करा पर वो कहीं पे भी अवेलेबल नहीं हुई। तो ये थोड़ा सा एक सभी छोटी सी मीटिंग आपसे
नहीं हम मीटिंग तो ठीक है, हमने अभी कलेक्टर और वो सीएमएचओ को बुलवाया है। बीच में भी एम्बुलेंस यहाँ खड़ी रहती थी, आई वाज वाचिंग एवरी डे, यहाँ बाहर खड़ी रहती थी। आज ही वो कुछ उन्होंने रीजन बताया कि कहीं चली गई। वी विल इंक्वायर इनटू दैट कि वेदर दैट देयर एक्सक्यूज इज रीजनेबल, मतलब जेन्युइन और सम।
एम्बुलेंस में एक एक्चुअली होता है जो टीचर वगैरह कहते हैं, तो अगर वो मिल जाता तो
जो खबर मिली हुई 1-1.5 घंटे पहले ही गेट खुला ऑलरेडी।
सर वो जब टू दी हॉस्पिटल उससे पहले का था सर, कि उन्होंने बोला कि साहब हमको यहाँ पे जब आए थे तो उससे पहले हो गया था। पर सर व्हेन ही वाज क्रिएटिंग प्रॉब्लम, वो सर यहाँ पे उस समय उनकी प्रॉब्लम हो रही थी और वो चीज सेम बाय दी वो भी इंसिडेंट तो था सर।
ठीक है देखते
वो कलेक्टर साहब भी यहाँ आए हुए, तो वो एक बार वो भी
आए क्या?
हाँ कलेक्टर साहब से मीटिंग हो गई, SHRI वो कलेक्टर साहब भी आए थे, तो उनको बोला कि आप पूरा दिन भर 8 से 8 जो है गाड़ी है, और एक MD डॉक्टर का बोला कि फुल टाइम।
तो आपने बोला कि 24 घंटे रखो गाड़ी यहाँ पे, यहाँ से इट कैन मूव समवेयर आधे किलोमीटर 1 किलोमीटर के रेंज में।
सर पिछले 15 या 20 दिन में सर और 1 महीने से सर इंसिडेंट्स बढ़ते जा रहे हैं, ये हम देखेंगे रेगुलर बेसिस पे। तो सर अब क्या कॉम्प्लिकेशंस में बहुत हो रहा है, मतलब स्ट्रेस और ये सारी चीजें कैसी हो रही है, तो यहाँ मतलब एक कंप्लीट सेटअप ही पूरा।
लास्ट टाइम मीटिंग आल्सो एक बार हुआ था ना, किस पे हुआ था, उसके बाद में एम्बुलेंस यहाँ खड़ी रह गई थी रोज। इवन लास्ट वीक व्हेन द ऑनरेबल चीफ जस्टिस वाज हियर एंड एम्बुलेंस वाज हियर,
अनफॉर्चुनेटली सर आज
नहीं थी। ठीक है, विल टेल देम कि यहाँ रखना ही है, और इनको चाइल्ड स्पेशलिस्ट डॉक्टर रखा है यहाँ पे जी, उसके लिए वो एवरी मेडिसिन आ रहा है,
मेडिसिन तक का सर प्रोविजन होना चाहिए सर।
बहुत सारी इंस्ट्रक्शन दिए थे, देखता हूँ आई जस्ट
जी सीओ कांग्रेस लेके एक बार बुलाया
तो बुलाया ना, इसलिए तो बुलाया उनको। इधर आपके रिक्वेस्ट के पहले ही मैंने खबर भेजी कि उनको बुलाइए आप।
जब एक प्रोसीडिंग तो बोलते रजिस्टर्ड हो जाए, जिससे कि ये हेल्थ इश्यूज का जो इस समय मतलब कि आपके पार्ट से भी ये हो जाएगी, प्रोसीडिंग तो डे टू डे फॉलो होने लग जाएगा, स्टेटस रिपोर्ट भी फाइल होंगी, तो देन इट विल एटलीस्ट जो भी चीज है वो सबको सामने आने लग जाएगी। तो in the betterment of the bar or for the betterment of the thousands of the advocates who are working in these cases, और बेंच भी सभी लोग मतलब यहाँ पे स्टाफ मेंबर्स भी है, तो ये सारे के सारे लोगों को बेनिफिशियल हो जाएगा। अगर सुमोटो अभी आप इंक्वायरी कराते ही why ambulance was not here today, let them give the explanation, they are coming। देखते हो
पासवर्ड नंबर 3
Yes.
Second application suspension or sentence. First application has been rejected on 19/3. Finance is completed within 9 years, 7 months and 4 days. प्रोसिक्यूशन का केस ये मगर डेडला जो डेडला है डिसीज ऑफ दिस केस माइनर प्रोसिक्यूशन का केस है तेरा 3 माइनर।
ये फर्स्ट एप्लीकेशन
सेकंड है 30 देख आज मैं 19/3/2019 को रिजेक्ट हुई मेरिट पे और प्रोसिक्यूशन के केस ये मतलब
कस्टडी कितनी हुई सी
2 साल 7 महीने 4 दिनों में और प्रोसिक्यूशन का केस ये मतलब कि दिस इज द डेडला मैंने और समझा जो ईरान का फादर है मतलब दोनों साथ में बैठकर ये मेरा पीने मतलब मैं रीड रिलेवेंट
हाँ रिजेक्ट है इसमें रिजेक्शन ऑर्डर का
ओनली स्टील का है मतलब
अच्छा स्टील three eyewitnesses, PW1, 2, 3, who have supported the prosecution case. They are coming using to allow the application for suspension of contempt.
एक तरह प्रोसिक्यूशन का केस देखे मतलब इसमें ये है मतलब कि 30/7/2017 को फरियादी पूम सिंह आटा ने थाना सिलावट पर हिसाब से की रिपोर्ट लेकर आई कि वह ग्राम डोंगर गांव ऊपरी पालिया में रहता तथा खेती किसानी का काम करता है। आज शाम करीब 6 बजे की बात है। इसका भाई डेढ़ लाख डिसीज मतलब पिता रामजिया तथा काका हंजिया पिता आकंजिया दोनों काका के घर से शराब पीकर आए। इसके घर के सामने इसका काका हंजिया भाई डेढ़ला को गाली गलौज कर रहा था। इसके भाई ने गाली गलौज को मना किया परंतु काका हंजिया नहीं माना। इसके भाई डेढ़ला ने बादल के साथ रखी लोहे की सांप सिर में मार दी जो काका हंजिया के सिर में लगी। इतने में हंजिया का लड़का हटा गया और बोला तुमने मेरे बापू को मारा और सांग डेढ़ला के हाथ से उड़ाकर जान से मारने की नियत से डकारिया ने इसके भाई डेढ़ला के सिर में मारा। जिसे बाया हाथ की कस्ती मारी जिससे मौके पर ही उसकी डेथ हो गई। ये तो घटना स्टार्ट हुई मतलब हमजा है आल्सो बीन डाइड मतलब D0 को वो क्योंकि वो डेढ़ला ने मारा था सांग भी उसी के हाथ में थी। ये आया तो मेरे पिताजी को क्यों मारा इसलिए वो उसी सांग को लेकर आयरन रात को डेढ़ला को मारा है। उसके खिलाफ भी 302 का केस को क्योंकि वो डाइड हो गया था तो इन्वेस्टिगेशन ऑफिसर ने 24 में एडमिट किया है ना जजमेंट की पेरस बनेगी हमें
बोले क्या ये नहीं हमारे पहले से इसको 1 2 3 तो बिल्कुल बोल रहा है कि मारा है करके
नहीं मारा तो है मारा इसलिए कि उसने पिताजी को मारा था उसे रॉड से आयरन रॉड ने जेडला ने हंजिया को जब मारा रॉड दी अपील आंटे में और फिर जब तो मारा उसके बाद में ये आया तो उसने उसका जो डेढ़ला उसके हाथ से आयरन रॉड ली फिर इसने मारा है। मारा तो है लेकिन मोटिव नहीं है। मोटिव का ये है कि उसके पिताजी को मारा इस कारण से मारा
तो मोटिव पिता को मारा मोटिव क्या कमी रहे
पिताजी को मारा तो मतलब पिताजी को मारा उसके लिए 9 साल 7 महीने 4 दिन हो गए। पिताजी को मारा तो कोई भी पिता को कोई मार रहा है तो बेटा बचाएगा ही कम से कम। ऐसा मोटिव नहीं था कि ये भी मर जाएगा तो ऐसा भी नहीं कि ये खुद आयरन रॉड लेकर आया और ऐसा भी नहीं कि इसने घर में मारी हो उसकी
दूसरे के हाथ से छीन के मार
दी ऐसा नहीं कि प्रिपेयर हो के मुझे भी मारना है मेरे पिताजी को मारेंगे वो दोनों शराब की हो।
क्या करना है कौन सा सेक्शन में जा रहा है
305 में जाएगा सडनली हुआ मतलब
पे चले जाए फाइनल सुना दो
अंडरगोन की प्रेयर थी फाइनल
ये तो उस पर कोई जजमेंट वगैरह वहाँ पे दो ठीक है कर ले रहे हैं
राहुल रिजर्व कर रहे हैं जल्दी जल्दी
फाइनल का है ना
यस नेक्स्ट आइटम नंबर 6 एसएचओ को कॉल किया था इसमें
आईटी में कॉल किया
इसकी नोटिस ही तामील नहीं हो गई थी 3 बार में इस वजह से
action shall be taken against the concerned officer. Order में ऐसा meanwhile the objector का नहीं अभी कहाँ आना है नहीं English class पे 2 weeks first में हमें तो ठीक नहीं तो सुन लेंगे आपको हमें तो notice सर होने से मतलब है yes we cannot wait for the and we cannot invite them कि आइए इसमें बहस करिए कोई जरूरत नहीं है
सर इसमें आपको एसएचओ नहीं है, आप एएसआई हैं उसी के। एसएचओ आज लाइन ऑर्डर की पोजीशन के कारण यहाँ पर अपेयर नहीं हो पाए। कल रात को एक हत्या हुई है वहां पर, उस हत्या की वजह से नहीं आ पाया। तो आपको
ये क्या है
ये एफआईआर है जो कल रात को हत्या हुई है।
तो भाई एप्लीकेशन लगाना चाहिए आपने
सर ये अभी पहुंचे,
ये भी आपको मालूम नहीं है आप
ये लेट पहुंचे हैं इसमें।
अरे लेट क्यों पहुंचे भाई यहाँ 10:30 बजे हाईकोर्ट चालू होता है और पहले आना चाहिए आपको। जब आपके एसएचओ नहीं आ रहा है तो फिर बुलाओ उनको एसएचओ को लेट भी थे
एसएचओ को बुला मतलब सर अचानक सुबह हो।
अरे भाई इसके लिए दरखास्त लगाना पड़ता है यहाँ पे। ब्लाइंड मर्डर हो तो कोई मर्डर हो कोर्ट के ऑर्डर को आप लोग ऐसा समझते हो कि कुछ मतलब ही नहीं है कुछ भी पास करते रहे ऑर्डर उसको कैसे इम्प्लीमेंट कराना भी नहीं आप बोलेंगे कि क्या हो गया ये हम ज्यादा बात नहीं करेंगे ऑर्डर पास कर देंगे सीधा समझ में अगर नहीं आ रहा तो ये लोग से एनीथिंग क्या करना है इनको समझाने से मतलब नहीं है समझते नहीं है इन लोग और आप भी वो कर रहे हो थोड़ा सा इसमें
सर हम तो आज ही
आप जहाँ पर्सनल अपील हो रहा है वो आप ही नहीं है Nobody is coming here. You are not filing application for dispensing with the personal appearance. That is the procedure. In every high court, everywhere they file here except Indore. ये सब शॉर्टकट मेथड लेकर ऑर्डर हम लोग बिना बोले ऑर्डर पास कर देंगे स्ट्रिक्ट
नहीं सर
आपके कोई भी ऑफिसर वी आर नॉट बॉदर्ड एट ऑल कि हमारा क्या होगा और किसका क्या होगा वी आर नॉट कंसर्न विद दैट
विल रिमेंबर नेक्स्ट टाइम।
आई एम नॉट दैट काइंड ऑफ अ पर्सन कर देंगे ऑर्डर जो करना आप करते रहे और बहुत स्ट्रिक्ट ऑर्डर पास करेंगे आप एवरी टाइम देख रहे हैं कि आपके यहाँ से एक भी केस में एप्लीकेशन की ही नहीं करी
विल रिमेंबर नेक्स्ट टाइम।
और उसी ऑफिसर की उसका एफिडेविट उसी का चाहिए ये एएसआई और कोई थानेदार है जो भी है उसका एफिडेविट नहीं चलेगा
कंसर्न ऑफिसर
जिसको मिला है उसी का एफिडेविट लगता है बिल्कुल सर एंड देन इफ द रीजन इज जेन्युइन विल एग्जाम if it is not we will give some other date जैसा भी देखेंगे सर हाँ चलिए बस लिस्ट बस ठीक है लिस्ट आफ्टर 2 weeks
नंबर 7 सर मैं आइटम नंबर 7 इसमें भी एसएचओ को कॉल किया था। एसएचओ इज प्रेजेंट रिपोर्ट द ऑनरेबल कोर्ट।
इसमें क्या नोटिस सर हुआ था कि
एक बार अकाउंट दिया नोटिस सर हो गया है
इसमें ऑर्डर कर देना इसके पहले वाला आफ्टर 2 weeks ये समझिए जरा अभी जो बोला ना आपके लिए भी लागू होता है यस ये कौन से थाने से आए ये
आप खरगोन
खरगोन और राजगढ़ अब 2 जिले का है ना अभी देखते हैं
सभी जिलों में लेटर लिख रहे हैं सर।
लेटर लिखिए एसपी को लेटर लिखिए
जी सभी कंसर्न एसपी
अगर एसपी विल बी कॉल्ड हियर है ना
जी
हाँ यस
नंबर 20
अर्थात 10 बार केस एडमिन आ रहा है इसी के लिए विक्टिम को फेयर करने के लिए
आज पॉजिटिवली लेटर दे रहे हैं सर।
ये क्या है WH
नंबर 20
लोग को ज्यादा ठीक है वी आर रिजर्विंग इट श्वेता भदौरिया के लाइट में दिस डायरेक्शन टू रजिस्टर एफआईआर कैन नॉट बी गिवन देखें इसमें क्या प्रेयर है दैट इज व्हाट लर्नेड सिंगल जज हेल्ड लिबर्टी हैज बीन ग्रांटेड टू alternative remedy to file a complaint under section 200 of the CRPC not registering the FIR. In the light of Shweta Bhadoria will dispose it of grant liberty to the petitioner
to file a private complaint under section.
They approach the magistrate under 156(3) or in the alternative file
Section
200. चलिए नंबर 25 ये क्यों पासवर्ड में हुआ था ये?
So because he was busy in some other matter.
अमेंडमेंट हो गया?
Yes, sir.
ठीक है, इनकम टैक्स सर।
मतलब इसमें एक्चुअली में इनकम टैक्स का लेना देना नहीं, हम प्रेयर क्लास देखेंगे, प्रेयर नंबर 3 माइनर। इसमें बेसिक चीज ये है कि जो पिटिशनर है उनको रेस्पॉन्डेंट नंबर 3 से 8 करोड़ 35 लाख रुपए लेना है। अब जब हम इसका पेज नंबर 16, 28 और 29 देखेंगे तो बिजनेस ट्रांजेक्शन है और ये लेन देन है। तो आंध्र ये केस पहले आंध्रबल गुवाहाटी हाईकोर्ट में गया था और उसी ग्राउंड पर डिसाइड हुआ है। इसमें आप सिविल केस लगाएंगे। आप प्रेयर क्लास का पेज पैरा 2 देखिए मैडम, उसमें उनको किससे कितना पैसा लेना है तो हम देखेंगे कि अर्थ रूरल को असम इलेक्ट्रॉनिक्स से पैसा लेना है और ये जो बिजनेस ट्रांजेक्शन है वो है पेज नंबर।
अमेंडमेंट पिटीशन फाइल कर दिया आपने? नहीं
कर दिए सर।
अमेंडमेंट किया है, ये डिलीट किया
अमेंडमेंट किया है।
पिटीशन के पीछे फाइल है, पीछे ना पीला पीला वाला।
Your Lordship, ARVIND counsel is appearing through us.
Just find out क्या है ये।
पेज नंबर 10 माइलर देखेंगे तो बिजनेस ट्रांजेक्शन।
कहाँ नंबर 3 कहाँ के? गुवाहाटी के हैं।
हाँ मैडम।
और ये पिटिशनर आसाम दिल्ली के हैं।
हाँ मैडम।
यहाँ कैसे मेंटेनेबल होगा?
वेरी सिंपल मैडम, आंध्र गुवाहाटी हाईकोर्ट ने इस इश्यू को डिसाइड कर दिया है।
अरे अभी बताइए कि इंदौर में कैसे मेंटेनेबल होगा ये?
वहाँ वो भी है, मैंने कहा कि नहीं, दिस इज सिविल मैटर and to be prosecuted.
We'll see subsequently. अभी relief can we grant the relief here?
ये फाइल डेट के बीच में कर दिया है क्या? अरे मैंने हाँ इसमें क्लियर है, इसमें 6 ऑर्डर हो चुके हैं ऑलरेडी।
ठीक है, सेम
ये लिटिगेशन क्या है, इसीलिए मैं वो क्लियर कर रही हूँ।
चलो
ठीक है, आप देखेंगे मेरे पास अनेक्षर नहीं थे पर इसमें जितने 16 अनेक्षरों का डिफरेंस गया।
Please, Your Honor, Your Lordship, I have been able to join. Yes. This is the bench, Your Honor. Okay.
Yes, please.
That's equal to the earlier ordered.
We are not able to hear you properly. There is a lot of distortion.
Just allow me, Your Lordship, just one minute.
ये पार्टी का डिस्क्रिप्शन तो गलत है। इनकम टैक्स डिपार्टमेंट की ऑफिसर।
Your Lordship,
please see the order. Please see the description of respondent number 2 whether it is correct. Can we proceed further?
Yes, Your Lordship, I'll explain that, Your Lordship. For a moment, please come to P1.
The income tax department can be a party. Either
Unfortunately, Your Lordship,
chief commissioner or the party in this case.
you are absolutely right, Your Lordship. The only difficulty is that the letter has been.
Should we proceed further than the claim against respondent number 2 cannot be granted. Income tax department के खिलाफ थोड़ी नहीं दे सकते आपको. There must be some officer by name, not by name.
फर्स्ट ऑथर है।
Authority.
हाँ, तो यहाँ पर उनको पैसा बस।
And then you are asking for a refund of claim from respondent number 3 which is situated in Assam. So how this Indore bench would have jurisdiction?
Because your lordship, if for a moment,
Okay, you are from Delhi, you are petitioner, you means you are petitioner from Delhi.
your lordship may please, for a moment, please turn to P1 because this letter has been issued from your lordship. This is a very peculiar case of
First amend the first item. First you have to amend it.
Please.
Annexer P1 किसने इशू किया उसको पार्टी बनाइए कमिश्नर को पार्टी बनाइए
मतलब इनकम टैक्स का लेना देना नहीं है
नहीं जो भी है इंडिया वांट टू चैलेंज
यस मैडम
प्रॉपर पार्टी को इंक्लूड हो पहले अभी तो सिर्फ इनकम टैक्स डिपार्टमेंट लिखा हुआ है
एक जब मैं 10 माइनर देखेंगे तो पूरा केस क्लियर
इनके बाद कंटेंट किसको वो करेंगे प्रोसिक्यूट किसको करेंगे अपन which officer
I follow your lordship. Your lordship, please give us permission to make that amendment and file it again.
file an application then in that case
Please, your lordship.
Please. So, Learned Council for the petitioner pays for and is granted weeks time to file application for amendment in the first item. Just after 1 week. Just next week.
Gratefully.
एक सेट हमें सप्लाई करेंगे 17 अनेक्शन है हमें कुछ भी नहीं मिला है केवल पिटीशन है बस
दीजिए ना पूरी कॉपी क्यों नहीं देते आप
सर वो अमेंडेड पिटीशन थी ना तो अमेंडेड पिटीशन
अमेंडेड के साथ में एक बार अनेक्शन तो देना पड़ेगा आपको
ओरिजिनल पिटीशन के साथ दिया था
नहीं हमारे यहाँ नहीं मिला है कुछ गड़बड़ है हमारे नाम भी नहीं है और पूरा पिटीशन
वहाँ पे 200-400 पेजेस रहते हैं अनेक्शन वहाँ देते नहीं आप लोग जनरली इतना चाहिए ना यू हैव टू सप्लाई द एंटायर सेट फ्रॉम पेज 1 टू लास्ट पेज बट यू डोंट सप्लाई
मतलब हमारे नाम भी मेंशन करवा दें क्योंकि वो केस फिर पता नहीं लगता कौन सा क्या है वो यूनियन ऑफ इंडिया आ जाता है और वो पिछली बार भी हिमांशु जी खड़े हो गए थे
उसमें लिख देना इनका नाम और रेस्पोंडेंट नंबर 2 में भी रिफ्लेक्टेड इन द कॉल लिस्ट ठीक है लिस्ट नेक्स्ट वीक ठीक है नो मोर केसेस टुडे